Good morning, Ms. Rivers. Are you able to hear us?
Good morning. Can you hear me?
Yes, ma'am. You ready to go?
Yes, I am.
Excellent. Let's find, is it Lee Arundel? Yep. And Ms. Mann. Go, and Ms. Maxwell. Okay, I think we've got everyone we need. Good morning. This is 16 SC 145115. It's State versus Christina. How do you pronounce your last name?
Jobert, sir.
Jobert. All right. Ms. Jobert, who is connecting to us from Lee Arundel State Prison. She's represented by Ms. Mann, who is online, and we've got Ms. Maxwell from the state. Ms. Joubert, we're going to talk about possibly modifying your sentence, but before we do that, I need you to tell me, assuming it's correct, that you are okay proceeding remotely. You have a right to be here in court, so we could pause this and get you transported here and do this in a few weeks, but we can also go forward with you appearing virtually like this. Are you okay with that?
Yes, sir.
Okay, you also have a right to have Ms. Mann sitting right next to you, but we can't do that if you are at Lee Arundel and she is at her undisclosed bunker. So she's going to be on the screen. You're going to be on the screen. Are you all right with that?
Yes, sir.
All right. If you need to speak with Ms. Mann privately, let me know and I can put the two of you into a breakout room where you can have a confidential conversation. All right?
Okay, thank you.
You're welcome. So as I understand it, in March of 2018, Judge Downs issued a modified sentence in Ms. Joubert's case, sentencing her to 15 years to serve 10 with the balance probated. So 10 in custody, followed by 5 on probation. In January of this year, Ms. Mann and Ms. Maxwell filed a joint motion to modify your sentence based on the guilty plea that you entered in February of 2017. I'm going to let Ms. Mann and then Ms. Maxwell tell me why they think that I should change your sentence, and we will take it from there. Okay?
Sir.
All right, Ms. Mann, when you're ready.
Good morning, Your Honor. Thank you for taking the time to hear our motion. Ms. Joubert's history started long before this case in Fulton County. As the court is aware, the very premise of fair sentencing is for graduated sentences. And unfortunately for Ms. Joubert, this was fumbled before she came to Fulton County. She was sentenced as a recidivist in this particular case. Because she does have 3 prior convictions. Her first case started, as most career, unfortunately, convictions do start with something somewhat minor, which was a theft by taking automobile, in which she received a sentence of 7 to serve 2, which seems like a mostly appropriate sentence. In 2008, and again in Muskogee County, she had a possession of methamphetamines, and she received a sentence of 10 years of probation. Unfortunately, she never received an option of treatment or counseling or anything of that nature. As the court might imagine, this is something that should have been offered, of course, and her history, traumatic history of abuse and drug use and need for counseling was divulged to her counsel in the court, but unfortunately was overlooked, sadly, as often is. She was released, and this led, unfortunately, to another drug case, unfortunately, a drug trafficking case in DeKalb County in 2012, where she received a harsh sentence of 10 years in 2012. Which obviously brought her to Fulton County, where she received the sentence that we are here now on today. We understand that a recidivist sentence was appropriate because of the and so obviously that's where she received the sentence here. Unfortunately, we know that a recidivist sentence is often used as a tool to negotiate a plea bargain to avoid a trial, which a trial was avoided here. Unfortunately, that recidivist sentence did follow through the sentencing phase. And once again, there was no treatment offered. I understand the prosecutor's point in using the recidivist sentence to achieve a plea bargain, especially since this was her second trafficking case at this point. And I believe that, you know, the system failed Ms. Joubert early on in her criminal history. And, you know, if the system had availed itself to her much earlier on, she would have been, you know, hopefully able to clean her act up and do much better with her life. She's an outstanding young lady in that she has been able to turn her life around while in prison, and really has availed herself of the programs in prison, and done the hard work indeed in cleaning herself up, as far as not using drugs, receiving an education, learning work skills, and regardless of a lack of, you know, real family support and community support, she's ready to do the right thing in all positive ways. And she reached out to me and told me her story in the most honest and humble way. And I said, you know, we will do everything possible to find a way to make this work for you. And I reached out to the Fulton County Conviction Integrity Office and said, let's find a way to make this right for this young lady. You know, she's had a really rough life, but I think that, you know, we can support her, and we can give her an opportunity, a last opportunity to do this the right way. And you have a lot of probation hanging over her head. And if she messes up, you know, this is her last opportunity, but I'd like to give her the opportunity to stay clean outside of prison, and to do a program that she has found all by herself. I haven't done any of the work to help her. She found a program while inside of prison, a sober living program that's going to help her to stay clean, to work, and to support herself. And so we were able to come to a solution with Miss Maxwell's help, to give her, you know, the opportunity to do the hard work while outside and to support herself. And so we're asking the court to remove the recidivist sentencing, and to allow her to serve out the rest of her sentence in the community, and to allow her to go to sober living, and to give her credit for the time she served, and to serve the balance of probation.
Okay. How much time has Ms. Joubert already served?
7 years.
Do you have the proposed order in front of you, Amy? Because I'm looking at the motion.
I believe it's 5 years and 10 months.
I think it's right at almost 7.
Almost 7 years.
July will be 7.
I'm sorry, Your Honor. I was looking at the order and not the information.
We can figure it out. That is figure outable. I just was curious because I saw the proposal was 15 to serve 5 years, 10 months, balance probated with this important special condition. I just wanted to make sure we were giving Ms. Joubert as much credit as she served, which would reduce a bit of the probation time. It sounds like it's going to be closer to 15 to serve 7 with the balance on probation. It's still 8 years probation, but that's different. And I just wanted to try to get that right. But I think Ms. Joubert would know the most how long she's been in custody. The offense would have been back in 2016, probably. Have you been in custody nonstop since then? You were not on bond or anything like that?
No, sir, I haven't ever been released.
Okay. And have you been at Lee Arendale the whole time, or you've moved around?
I went to RSAT Pulaski for like 4 or 5 months. And then when I got sentenced to when I got this sentence for here, then they took me out and brought me to diagnostics. But I've been here the entire time.
Did you finish RSAT?
No, like I went there for my parole violation, and then I went back to the county and I was sentenced to, the time I have here, and they snatched me out of it in the middle of to go to diagnostics.
So your parole or probation or something from the DeKalb case, that's what got revoked?
Yes, sir.
Okay. All right. How did you find Tides of Change?
I got with a lot of different counselors, and they gave me, and I had different appointments with the people who help you prepare for leaving, like freedom preparation. And like I got a phone book, like I diligently, like it took a long time, and it took a lot of weeding out, because most places they only accept men or women with children and stuff like that. So I looked for the most appropriate one outside of any of my stomping grounds, and like within the parameters of what I know that was required of me. And I spent a lot of my mom's money on phone calls.
Okay. Is Tides of Change something that you have to pay for? And if so, how are you going to do that?
Well, they have, within walking distance, they have 3 different places that I have actually connections to get a job at. Like one of my friend's sister is actually the manager at the pizza place across the street. And then they have a Joe's. They have they have several places, within walking distance, but 2 of them I actually have connections into.
And if I clarify, Your Honor, Tides of Change was the original program that we planned for her to go to when we filed the motion. But some time has passed since we filed the motion. That place is no longer available. There's no longer bed space. So at this point, she has a space available at Apex Sober Living, which is a separate facility, which is actually located in Roswell. But she will have to pay for bed space there. But they also will assist her in finding a job so that she can pay for her space while she's living there. She'll be able to work. So she'll be paying her own way.
Okay. You mentioned your mom, Ms. Jobert. Is she someone who is active in your life? Is that a resource when you get out, or is that actually going to be a source of stress and complication?
She's a source of maybe sometimes a little bit of both, but she's in North Carolina, so I won't be around her that much.
You'll keep your distance. All right. Yeah. Do you have other friends or family in the metro Atlanta area, or will you be starting anew?
I'll be brand new. Like I'm from Columbus in Muskogee County, and so it'll be, I'm not going to sit here and say I don't know anybody at all ever, but like I'm from my hometown is Columbus, Georgia, like 2 hours back.
Okay. All right. Do you have kids?
No, sir.
All right. Ms. Maxwell, what do you want to add?
I just want to add, Your Honor, I'm with the Conviction Integrity Unit, and what we do is we look at how we sentence now and how we sentence then, and look at some of the issues that we may not have considered. One of the things in her case is that she's a survivor of domestic violence. We really haven't been paying attention to those kinds of issues. The other thing that shocked me looking at this is she's really never had any substance abuse counseling or any opportunity to really look at those issues, and clearly she has those issues until she was in prison. I've spoken with the prison officials. They are impressed with her. She's really, really trying. The other consideration is Lauren McCauley, who is in court right now. I see her. She has worked with Ms. Jobert. Ms. Jobert was one of her witnesses in a terrible, terrible case, and she's gotten to know her. And Lauren has been a very strong advocate in trying to get her resentenced and getting her to a place where she can practice sober living and move to a different level in her life. And so I don't know if Lauren wants to speak on that or not. But those were our considerations in proposing the resentencing. I'm really super impressed that she found her own place to live, and made it clear that she wanted to be in a new area so that she didn't fall back into any of the habits that you can fall back into. We all know that drug addiction is something that's really hard to get beyond, and I think she's made some really great steps.
Okay. Ms. McCauley, is there anything you want to add?
Yeah, sure. I'll just sit here at the table,
Sure.
if that's okay.
No, that's fine with me.
So I got to know Christina when I picked up a case that was previously handled by Kara Convery in my office. It was a case that went to trial in November. And Christina was already an identified witness and had testified at a prior hearing. But it just seemed like and she was very cooperative when I had an opportunity to speak with her. She was very forthcoming. She never tried to lie or mitigate or anything in her testimony, which was not something that I think she wanted to do, but it was something that we asked her to do, and she was, she did it because we asked her to do it. And I think at trial, particularly at trial, well, also with my meetings with her previously, because she is truly just a very lovely person, not someone who you would anticipate would be serving a considerable prison sentence for drug trafficking, but just a nice person. And I think, honestly speaking, a good person at her core.
And when you were working with her, she was in the midst of this sentence. In other words, she was in custody. It wasn't.
She was at Arrendale's state prison. She
Okay.
shared with me some of the things that she was experiencing at the prison, which was horrendous, that no person should experience. But also it struck me when she did testify of just her, and it struck the jurors as well. This was a case that was tried in front of Judge Richardson, just how candid and genuine she was in her testimony. And what was compelling her to be honest and forthright with what had happened in her life and what had brought her to be a witness in that case. I think, just speaking from my own experience as a prosecutor and handling these cases, I read through all of her prior police reports for all of her sentences. And I think that particularly the sentence that she is under now is not appropriate for the circumstances in which that put her there. And I understand she has a criminal history, but she also is someone that has struggled with substance abuse, and that is completely overlooked and not treated. And we are incarcerating her because she had an addiction or has an addiction problem. And that really struck me as well. I remember speaking with Ms. Maxwell immediately after, actually in the parking lot of Arrendale State Prison. And I said, I don't care if she's going to testify in my case. I don't care if it goes sideways or not, but you have to modify her sentence. She can't sit in prison for 10 years when we are sending people to prison for far less time for far more serious offenses.
Okay. Got it. Ms. Jobert, is there anything you want to add?
There's probably 30,000 things I want to add, but ultimately, like, I have been here 3 times. Like, I pretty much grew up here. And there's always been different opportunities. There's always been different like classes and such. And like this time is the first time that I ever full throttle like took advantage of every single one of them and like actually enjoyed or like gave it my best shot. And then also at the same time, like this is the first time I've ever been in prison, and there's been so many negative opportunities, what I mean? Like, because before there was not drugs in here were like unheard of, and like now they're super rampant, and like I can pass the drug test anytime, and that's like a really new and good feeling for me. So I mean, I really didn't think that like I was really gonna get 10 years to the like door for drugs, and then like I couldn't ever accept it, but then like sometimes I had to accept it, but like I just really want one opportunity to just see if I can conquer it with any help. Cause like I've never done anything, not even had a meeting outside of prison. And so I just, maybe my one shot, like just one chance. I know I've had a few chances, like, but just one chance at recovering.
How do we work it, Ms. Mann or Ms. Maxwell, so that I am confident that Ms. Jobert goes to Apex. If she were here and we were structuring the initial sentence, I'd be able to do a transport order, and I would know that Ms. Jobert would leave Fulton County custody to be delivered to Apex, and there wouldn't be that risky week of she don't really have a place to stay. Maybe she shows up at Apex. Maybe, look, she's back in Columbus again. And that's not what I want to have happen.
I understand that concern, and Ms. Maxwell and I have had a couple of conversations about that, Your Honor. We have one complicating factor that we cannot control, and that is the lovely state of Tennessee. There is a detainer in Tennessee that should not exist, that I cannot control the rest of me. There is a case from 2016, I believe, that actually was already dismissed and expunged. Unfortunately, Tennessee can't get their books right, and they still have a detainer out for her for that same exact case. I've already shown them with their own paperwork that their detainer and their warrants are for the same exact case that was already expunged, but they've stopped responding to my emails when I showed them that it's the same exact detainer and warrants. So I could ask you to give me paperwork showing that Apex has to transport her from Arundel directly to their facility. But my concern is that Tennessee is going to insist on bringing her to their state to correct their detainer and their warrants because they cannot figure out their own paperwork.
That is a complicating factor. So we could end up with a scenario where in Tennessee?
Hamilton County.
Chattanooga.
I've done everything possible to straighten this out before we came to your court today, but they just can't seem to get it together.
So
I too have tried, and I can confirm that these are cases that have been dismissed, but they can't figure out who needs to fix it. So
if I were to modify the sentence so that it's effectively you've served the custodial portion, then Ms. Jobert goes to Hamilton County and then might just be released there. So she's up in Tennessee.
Well,
it is our hope that once the detainer kicks in, that maybe at that point we can solve it. So I'm hoping that we can keep her from having to go to Tennessee to fix this. But it may be that she ends up in Tennessee and has to come back.
Okay. That does complicate things.
Yes.
Was it your sense, if Tennessee's hold didn't exist, was it your sense, Ms. Mann, that Apex would actually come all the way to Lee Arundel and pick Ms. Jobert up?
I've talked to them there, and they're willing to do that.
Okay. All right. Well, let me think about that. Let me be clear. I have no problem modifying the sentence as the way you all are recommending, which would mean two primary changes. I would reduce the custodial portion to close to time served. We'll do the math on our end to see how close to 7 years it is, whatever the number is. And then I would impose as the primary special condition of probation that Ms. Jobert enter into and complete. Is it complete? How long ought I expect you to stay at Apex Sober Living? Because certainly if you're there for 1 month and you decide you're going to go run your life elsewhere, that's a violation of your probation. But I don't want to say 6 years because you don't need to be there for 6 years. What's your understanding?
Their graduation is 6 months.
Okay. All right. I'll say at least 6 months Apex Sober Living. And then I may have a few other conditions, but they're just going to be consistent with you working hard to stay clean. So it'd be drug screens, things like that. I would need, and you can just email it to Ms. Nelson, the address for Apex Sober Living. And I guess you all can email it to Ms. Nelson a little more about this Tennessee detainer. I want to see if maybe combined defense attorney, DA's office, and court, we can get this cleared up. Because I'm not real excited about leaving that hanging.
Thank you, Your Honor. I will happily do that and greatly appreciate any and all assistance we can have.
Okay. Is there anything else, Ms. Mann, that you think we need to cover?
That is everything, and we greatly appreciate you, Your Honor.
Okay. Ms. Maxwell, anything else on behalf of the state?
No, there's not. Thank you.
Ms. Jobert, you mentioned that, hey, if I could just have one chance, and then you caught yourself and said, gosh, I have had a few chances. Maybe a better way to describe this would be important, big last chance. You have been able, through your persistence and the steps you've taken to redirect your life, to accumulate an impressive set of supporters. Ms. McCauley, Ms. Maxwell, Ms. Mann. There's only so much they can do if in 9 months we're together again and you were carrying around a big sack of methamphetamine. That won't end well. And you know that better than I do, but I want you to understand that you will have shown that you're not ready to be out and be safe, because that's really what this is about. It's about you being safe. And frankly, if you've got a trafficking quantity of meth, you're making life unsafe for other people as well. And I'll be disappointed, but I'm not going to be real upset if we need to then say, it's just, you can't be in circulation because you're making it unsafe for you and for other folks. But I'm optimistic that you are more than ready to do something different with the support that you should have received a long time ago. I think that's the big lesson here, is that we need to always be mindful. Sentences ought to be structured to help the person move forward and not repeat some of the missteps that happened before. So I will modify the sentence. It will be a sentence that gets you out of custody, but I want to see if we can get you out of custody directly to Apex and not to Hamilton County. So don't look for the paperwork right away, but you certainly should reach out to Ms. Mann. If it's been a couple of weeks, hey, I haven't heard anything, she'll let you know what's going on. Okay.
Okay. Thank you, sir.
You're welcome. Good luck with everything. And thank you to the folks at Lee Arundel for getting you on Zoom.
Okay. They're not in here, but
Ms. Maxwell, you will work with Mr. Young to do something akin to this rather than an extraordinary motion for new trial in the other case you're working on that's in my division?
Yes, we are working on it today.
Fantastic. Okay, thanks. You all are free to go.
All right, thank you,
Your Honor.
Ms. McCauley, the trial that you are in and your colleague is in next door, is it an all-weeker? Is it a...
Right, at the pace we're going, we'll be there for 2 weeks.
Okay.
But I think maybe we'll finish on Tuesday at this rate.
Okay.
Give 18 witnesses.
All right.
Yeah.
Good luck.
Thanks.
All right. Before we do anything else, let me close this. Mr. James, you are on at 1 o'clock. I let your lawyer know it's 1 o'clock. So you should dial back in, same number, same everything. But that's 1 o'clock. If you can hear me. Let's turn to Ms. Lovejoy's situation, please. And I see Ms. Reinhardt. How are you?
I'm good. Good morning.
Good morning. Who is here's Ms. Sellers. We've got 2 of the 3 folks. Where's Ms. Lovejoy?
She is here. I saw her earlier. Let's see. And Dr. Shores is going to testify.
Excellent. So would she, oh, there she is. Ms. Lovejoy, can you turn your video on? And same with Dr. Shores.
Emma, if you can hear. Your Honor, I'll take a moment, see if I can call.
Okay, great.
Okay.
I see her there. I see the person on. Hey, Dr. Shores, can you hear us?
Yes, Your Honor. I was just calling over to the house to make sure they're trying to get on video.
Great. Okay. Appreciate it. It looks like Ms. Reinhardt might be doing the same thing. I just want to make sure you were looped in. Ms. Feely, the only other thing we have for this morning is Mr. Peck. You're welcome to be here. I just didn't want folks.
No, I'm happy to be excused. I just, when they're criminal calendars, I want to make sure nobody.
Oh, just comes on in. Okay. I don't know who else is here. Looks like some law enforcement. But otherwise, I think we're good. Ms. Abbasi is doing her best to get here from Coweta. But then we're back on at 1 o'clock with hopefully lots of your stuff.
I'll see you.
Okay.
Okay, I did reach them, so let's see.
Yep, she is now on. The camera's not doing anything, but the video is running. Ms. Lovejoy, can you hear us? It's progress. They activated it all.
They seem to be having technical difficulties. Is there a call-in number that they might be able to use?
As in, like, could they use a phone to call into Zoom? Yeah, let me look at.
I apologize. We're with the state, so we do not have great equipment.
No problem. Yeah. Do you want me to just tell you the number or put it in the, it's not a secret number, or put it in the.
If you could just tell me, I can get it over to them.
Sure. So this supposedly should work. 470-250-9358. And then the meeting ID is 959-6016-5786. And then they have to put in the passcode, which is 715-573.
I'll get that over to them right now. Thank you.
Thanks.
Oh, speak of the devil.
And Your Honor, if I could be excused, I thought all my stuff was this early this morning, but I think I'm around.
Yeah, you guys got to read the calendar times. 1 p.m. is everything else. Got 3 things this morning. Ms. Hall is here for Mr. Peck. Ms. Sellers is here for Ms. Lovejoy. And then we had all the virtual appearances for Ms. Jobert. So I'll see you at 1.
Yes, Your Honor. I'll be
And
back.
I do see them on camera, Your Honor.
Okay. Is it a different entry?
Yes, Your Honor.
So let me unpin this one, remove spotlight, and see up right there. Okay. Great. Okay. We see it. All right. Let's get started. So this is Z40427, State versus Emma Lovejoy. Good morning, Ms. Lovejoy. Can you hear me?
Yes, I can. Good morning.
Good morning. I'm Judge McBurney. I don't know if we've met before. I've seen your name before and I've read a little bit about you, but I am the latest judge to be assigned to your case. You have had many judges work with you. Your case is mine now, and we're going to have a conversation about how you're doing and what ought to happen next. We have Ms. Reinhart, who I know you've worked with for many years. Dr. Shores, who spent some time with you and prepared a report for me that we're going to be talking about. And then Ms. Sellers, and I will add her so you can see her. Where is that? Just going to have a crowded. There's Ms. Sellers. And Ms. Sellers works with the district attorney's office and is going to share with me the district attorney's office perspective on what ought to happen. Ms. Reinhart, I'm going to start with you, but let me give you an overview of what I understand is going on. Ms. Lovejoy was charged with aggravated assault way back when and was found not guilty by reason of insanity in 1992. By my math, we have far exceeded the statute of limitations for this offense, but we're in a different space because of the outcome of that case. And so you and Ms. Sellers are going to educate me as to why we keep reconvening, not because I mind, I'm happy to do it, but why the court retains any involvement in this at all. More importantly, if we fast forward, I'm going to skip over a number of years where it sounds like Ms. Lovejoy was doing okay, then things weren't going so well, and she was in and out of a couple places. She's in a place now where things appear to be going okay, and it is Dr. Shore's recommendation that we maintain the status quo, that Ms. Lovejoy continues to meet the criteria for outpatient civil commitment, and that she continue to receive the level of support that she is. It sounds like there's sometimes a little bit of a disconnect between the need for some of the medication and the desire to take it, which is probably a good reason to ensure that Ms. Lovejoy has some folks who are supporting her as she's moving along. But I'm going to want to hear from everyone on this, and I'm going to ask you, Ms. Reinhart, as I think the one who's been with this the longest, to help me understand why we come back to court on this, given the age of the case, and then your thoughts about what we ought to be doing going forward.
Well, as far as why we still have the cases, because it was a not guilty by reason of insanity, it's an indefinite sentence, for lack of a better word. And so the amount of time doesn't necessarily correlate with how much time she could have gotten had she been found guilty. Because of course, if that was the case, more than likely she would have been out of prison years and years and years ago. Ms. Lovejoy currently is asking the court for a full release. I talked to Dr. Shores about it. And of course, we have different points of view about that. And we would like to talk to the court about that and have Dr. Shores testify as to her rationale for why she needs to stay. And then I think Ms. Lovejoy wants to address the court as to why she feels like it's time for her to be released from custody supervision. You know, all of the mental health resources will still be there. So she would still have access to everything that she has access to now. It just wouldn't be supervised by the court. And that's, I think, where the sticking point is with Ms. Lovejoy and the department as to whether or not a court order needs to be in place in order for that to happen.
So that I follow what you're saying, if I granted Ms. Lovejoy the relief you're advocating for, she wouldn't move from the place where she's living. She'd have all the same care. It just wouldn't be, I guess you will, enforceable. It wouldn't be a court saying that, but the good folks there who are working with Ms. Lovejoy and helping her care for herself wouldn't say, well, if there's no court order, there's the back door. You're on your own in wherever she is.
Right.
Okay. Well, then I'll need to understand what purpose court supervision plays in this process. Then, if Ms. Lovejoy's situation wouldn't change, if I were to say you get full release, I'm confident there's good reason for why Dr. Shores wrote what she wrote. So I guess we'll work through that as she talks to us. So do you want to? Well, let me hear from Ms. Sellers just real briefly as to the state's perspective, and then Ms. Reinhardt, if you want to ask Dr. Shores some questions, we can handle it that way. And I'll note that I think we have Kelton Dutch on as well. I don't mean to exclude that person if that's an appropriate source of information as well. I just assumed that we'd start out with Dr. Shores, but we can rely on any source of info you all want me to hear from.
And Your Honor, also, I believe that one of the ladies in the picture is Ms. Jackson. She runs the group home there. She can testify as to her being able to stay or not stay as well. Okay, great.
So Ms. Sellers, good morning. Tell me the state's perspective and anything you want to add sort of procedurally as to why we're here.
Well, procedurally, we're here under 17-7-131. And it's the state's understanding, just based on what the calendar said, that the defendant is requesting a full release. Mm-hmm. I'll note that the statute says that the defendant should make an application for release. And I don't know if just an oral application is sufficient, but I will note that and note that in coming into this, the state does not know the basis of why the defendant is asking for release, which is in opposition to what the Department of Behavioral Health and Developmental Disabilities is opining in this case. So the state would object to that, the basis of, what's the basis of this release, and the basis that the application is insufficient.
Okay.
Say on its face, but because it's only an oral application, as I know of.
Okay.
Additionally, Ms. Lovejoy's commitment is governed by the outpatient civil commitment. And so that's under 3731. And in that, it specifically states outpatient civil commitment is a person who is mentally ill and who is capable of surviving safely in the community with available resources or supervision from family, friends, or others, who, based on their psychiatric condition or history, is in need of treatment in order to prevent further disability or deterioration that would predictably result in dangerousness to self or others, and whose current mental state or the nature of their illness limits or negates their ability to make an informed decision to seek voluntarily or to comply with recommended treatment. So those are the parameters for which the court should determine if the defendant should, or Ms. Lovejoy should remain on outpatient civil commitment. And lastly, I will state that the burden of proof is on the party that is bringing this conditional release, so that's the defendant.
Okay, understood. And we have everyone we need today to have a meaningful conversation. So I think we'll do that. If it turns out that Ms. Reinhardt needs to make a written application, I'll let her do that. But we'll gather the information we can today, since we've got Dr. Shores, we've got Ms. Lovejoy, et cetera. I think Ms. Reinhardt's about to flesh out the basis for her request. Of course, she's making it on behalf of her client, and it may be as simple but profound as that's what Ms. Lovejoy is asking for, in which case that's good to know. That's certainly not controlling on me. And I will be sure to give the state a chance to respond if there is information that you'd want to present that you don't have today because you're learning things on the fly. So I won't be jumping up out of my seat saying, here's what we're doing today. I'll be processing this, and we'll do it in a methodical way. Okay?
Yes, Your Honor.
All right, Ms. Reinhardt, when you're ready.
Okay, Your Honor, we would call Dr. Shores to testify.
All right. Deputy Gordon, if you could come on up and swear Dr. Shores in, please.
Raise your right hand. Do you swear or affirm that the testimony you'll give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
You can lower your hand. State and spell your name for the record.
Darcy, Darcy, Shores, Shores.
Dr. Shores, where are you currently employed?
The Georgia Department of Behavioral Health and Developmental Disabilities.
And in what capacity are you employed?
I'm a forensic psychologist. I'm the director of Community Forensic Services West for DBHDD.
Okay. And in that capacity, have you had an opportunity to get to know Ms. Lovejoy?
Yes, I interviewed her for the evaluation that was submitted to the court back in April.
Okay. And what is her current diagnosis?
Her current diagnosis is schizoaffective disorder, bipolar type, and a history of substance use disorder.
Okay. And what meds is she currently taking?
She's taking Haldol Deck, which is an injected, long-lasting antipsychotic medication. She's taking Clozaril, which is a second antipsychotic. She's taking Lamictal, which is a mood stabilizer. And she's taking amantadine, which is used to treat side effects from the other medications.
And where does she receive those medications?
The Haldol Deck she receives at the Community Service Board because it is an injection, and the other 3 she receives at the house.
Okay. Would those medications continue if the judge granted the full release?
Yes, all of her mental health services would continue if she was granted a full release.
Okay. And what type of treatment is she receiving as far as mental health?
She goes to the Community Service Board. She has regular psychiatric visits. She goes to day treatment and does have a case manager at the local Community Service Board.
Okay. And how does she get to her day treatment program?
She's transported by her residential provider.
Okay. And they would be able to continue to do that without order?
Yes.
Okay. Are you aware that Ms. Lovejoy is asking the court for a full release?
Yes.
Okay. Now, she's currently residing where?
She is residing in Milledgeville at the Charlton home.
Okay. Is that the least restrictive environment for Ms. Lovejoy?
In my opinion, yes.
Okay. Are you aware that she wants to move to an apartment eventually? Yeah. Okay. Has that been explored?
No.
Okay.
How would she, I'm sorry to interrupt, how Dr. Shores, if Ms. Lovejoy says, hey, I want to move somewhere else, how does she afford that? Because she gets benefits, or, I mean, I'm not prying into, she may have won the lottery, but just simply saying, I want to live in an apartment. It's not like the good folks where she's living now would say, great, we're going to go get you an apartment. They run that house.
She gets benefits.
Okay.
Okay. Now, are you aware of any family support that Ms. Lovejoy has?
I believe she's close with her daughter.
Okay. in the next year, if the judge, depending on what the judge does, what is the plan for her as far as her residential placement?
There is no plan to change her residential placement.
So that would be the plan permanently for her to stay at a group home?
Yes.
Okay. What about supervised apartments?
If she's granted a full release, she can go wherever she would like. We would not be recommending forensic apartments in the foreseeable future.
Okay.
Is a forensic apartment the same thing as a supervised apartment?
Not necessarily. There are forensic apartment programs that are specifically for forensic individuals. And there are also apartment programs for non-forensic individuals.
What's a forensic individual? Meaning someone that is under DBHDD care through a court order?
Yes, Your Honor.
If I were to grant Ms. Lovejoy the relief she's seeking, does that mean that basically DBHDD pulls out of her life and I wouldn't get annual reports? You wouldn't be checking on her once a year to make sure everything is okay?
Yes, Your Honor.
Okay.
Would she maintain her case manager in the community if the judge granted the full release?
She would be eligible to receive all the services she's receiving now in the community.
Okay.
Now, are those services through the CSB or are there services that Ms. Lovejoy is getting through DBHDD?
She is receiving services through the Community Service Board, the CSB, the Oconee Center in this case. She is living at a DBHDD staffed and funded home, but that is independent of her forensic status. If she was granted a full release, she could continue to reside there indefinitely.
In your experience, Dr. Shores, and I'm going to give Ms. Reinhart and maybe directly Ms. Lovejoy a chance to voice it for themselves. Why does a client, a patient, an individual want to move from a group home to an apartment, supervised or forensic? What's the difference?
Independence. Right now, she's living in a home, just a regular old house with 5 other people and staff on site. Mm-hmm. So an apartment, she would be either in an apartment by herself or with a roommate. So there is a level of independence that you get in an apartment you just don't get when you have 5 housemates.
Because you have fewer to no roommates would be the biggest change.
Yes, and there would not be staff in your living space as there is with a group home.
Okay. With the supervised apartments, there could be staff in another apartment so that there's someone on call, if you will, but not in the same shared living space.
Correct.
Okay. In order for Ms. Lovejoy to continue to benefit from the services at the Oconee Center, she would need to find an apartment that is in that county. If she found an apartment in Johns Creek, she couldn't go to the Oconee Center. In fact, she'd be in a county that doesn't have a CSB.
Yes, Fulton County is unique in that, to the best of my knowledge, every other county but Fulton does have a dedicated CSB, and she would be eligible for services at any CSB.
If Ms. Lovejoy was wise and stayed out of Fulton County and went somewhere with a CSB, would her records, the medication she's taking, the diagnoses, et cetera, would that be readily transferable to that other CSB, or they'd just be starting from scratch?
No, it would be readily available. She would just need to sign releases of information so the Oconee Center could send her records to the new provider.
Okay. Got it.
And if Ms. Lovejoy is granted a full release and she wants to leave, her current residential providers and Oconee Center would work with her to set up services wherever she wanted to go.
Assuming she let them know what she was going to do. If she simply said, thanks, I'm out of here, we'd be relying on Ms. Lovejoy, maybe her daughter, to help facilitate that handoff.
Yes, Your Honor.
If I read your report correctly, it sounds like maybe in the past, Ms. Lovejoy has left the facility without necessarily coordinating the transfer of care and supervision. Did I read, or that's incorrect?
Yeah, no.
Okay.
The last time she was in the community and she had to be returned to the hospital, it was due to a medication change. And the time before that, it was because she was in an unsafe placement. So she was returned to the hospital for her safety through no fault of her own.
Okay, got it. So the third conditional release in April of 2018, then it says she was discharged to Charlton Central Care. That's actually where she went to?
Yes, and she's still there.
Okay, got it. Okay, all right. I interrupted you, Ms. Reinhardt. You should press on.
Oh, well, I think I was actually about done with Dr. Shore, so I'll turn it over to Ms. Sellers.
Okay, Ms. Sellers?
Thank you. Good morning, Dr. Shores.
Good morning.
Tell us about Ms. Lovejoy's diagnosis. You said that she was diagnosed with schizoaffective disorder, bipolar type. What does that mean?
A schizoaffective disorder bipolar type is a mental illness where you see symptoms of schizophrenia and a mood disorder. In Ms. Lovejoy's situation, she has a history of paranoid delusions, irritability, verbal aggression, poverty of thought, and periodic non-compliance with treatment before she landed with DBHDD back in 1992.
So you said a number of things about Ms. Lovejoy's diagnosis, her schizoaffective bipolar. The first thing you said was paranoid delusion. What does that mean for Ms. Lovejoy?
That means she believes that others are plotting against her, trying to harm her, that very bad things have happened. You know, for example, at one point when she needed to be stabilized, she was refusing medication because she believed it was poison and was causing a bleeding disorder. When I did her annual evaluation, she reported that her children had been stolen and were placed on the black market, and that had something to do with the charge for which she was found NGRI.
To your knowledge, does Ms. Lovejoy have children?
She does.
She has a daughter. And refusing medication. You said refusing medication, but I couldn't hear everything that you stated why she was refusing the medication.
At one point, after a medication change and she started decompensating, she was refusing to take one specific medication because she believed it was poisoning her and causing blood issues.
21 pills a day, that was enough. 21 pills every day. And I did that ever since 1991. And some of my friends had the same problems with medication and I was going to die. I'm still standing. I didn't quit the medicine. I stayed strong and fed myself and kept everything in the right pocket.
You also mentioned that another symptom, or I guess how it presents for Ms. Lovejoy, is verbal aggressive, that she's verbally aggressive. What does that mean?
Verbal aggression is typically irritability, typically threatening others, accusing others of wrongdoings, stealing her things like that.
Okay. And you also mentioned poverty of thought. What does that mean?
Poverty of thought is when you talk to somebody and they can't really talk back, not because of a lack of interest, but because their brains are just not generating thought and replies to what's going on.
And you may have mentioned another symptom of her schizoaffective bipolar type.
Irritability?
Irritability. Okay. Was that the only one?
I think so.
Okay. And how does that present itself, irritability?
Easiest explanation is being pretty cranky.
And I guess, how does that show up for Miss Lovejoy being cranky?
Other people get on her nerves very easily.
And you mentioned that Miss Lovejoy takes several medications. There were 3 different types of medications, or 4 different types. Is that correct? Medications that she takes?
For mental health reasons, yes.
For mental health reasons. And one is an injection?
Yes, Haldol Deck.
Okay. And those are, you mentioned they are antipsychotics. What does that mean?
2 of the medications she's on, Haldol Deck and Clozaril, are antipsychotics. They are used to treat delusions, hallucinations, bizarre speech, bizarre behavior.
And the mood stabilizer?
That was Lamictal, used to treat irritability and aggression and mood swings.
And with these medications, does that keep her mental illness in control or stabilized?
It does keep her mental illness stabilized. So, but she does still periodically voice delusions. She is still reported as being irritable. And there is some mild paranoia too.
Okay. And how does that mild paranoia show up?
Claiming others have stolen from her when she's just misplaced objects, claiming, somebody stole her money when she spent her money and there are receipts to prove that she's the one who spent the money.
And what would happen if Miss Lovejoy were to stop these medications or stop any one of these medications?
We would expect at some point for her mental illness to be exacerbated. We would expect to see more delusions. We would expect to see more paranoia, more irritability, more aggression, probably some bizarre behavior.
And previously when she, I guess, stopped some of her medications, is that correct? There was a time when she stopped some of her medications.
There was a time when her medications were changed. And as she started, her medications were changed. It was nothing to do with her. This was not her fault in any possible way. Mm-hmm. Her medications were changed. She started to get worse. And as she was getting worse, her paranoia increased where she did not want a specific medication anymore.
Stop.
Prior to her medications being changed by her physician, she wasn't happy taking the medications. She would only say she's over medicated and she doesn't need them, but she was taking them.
I never miss a pill since I've been here in the past 10 years. I did take my medicine.
That's good. We want to make sure you keep taking it.
And when she began to refuse to take the medications, what happened? Did she have to go into the hospital because of this?
That was many years ago before I got involved. So she did have to go back to Central State and she stayed there about a year and a half.
Okay. Does Miss Lovejoy understand what her mental illness is?
It's my opinion she doesn't, based on what happened during the evaluation back in March. I asked if she thought she had a mental illness and she kind of talked around it and, said she doesn't think she has schizophrenia, that she's over medicated, and that the medications really don't benefit her.
felt like I was being punished, but I wasn't. I took the medication, which they told me. I got stabilized. I feel much better. I feel like I can cope with life and coming on.
And so, you opined in your most recent evaluation dated April 6, 2023. Can you just talk a little bit about that evaluation? What is the normal procedure for making an evaluation as it relates to civil commitment?
The normal procedure is that a psychologist will sit down and interview who we're writing about. We will gather all the information we can from residential providers, from treatment providers, and we will collate all that information into a report to the court.
And did you follow these procedures in this case?
Yes.
And when did this examination happen?
It happened in mid-March of this year.
And where was the examination conducted?
It was conducted at Charlton House, her residence.
Okay. And under what conditions was the examination conducted?
I'm not sure what you mean.
Were you in person, via Zoom? Were you in a room together? How was the examination conducted?
It was in person with the Charlton residential team and her forensic community coordinator, Mr. Dutch. Ms. Lovejoy came in and spoke to all of us. Okay.
And when you say the team, I guess who were the players that were in that evaluation? Who were all of, not specifically names, but who were the people? Case manager, things like that. Who were the people?
Ms. Jackson, who is the house lead, was there. Mr. Lewis, who's the team lead, was there. The behavioral health counselor was there. Ms. Solana Prosser, who is the administrative head of all of Central Care, was there. I think there was another staff member there.
Okay.
And Mr. Dutch was there.
Okay. And what's Mr. Dutch's title?
Forensic Community Coordinator.
And approximately how long was the interview?
20 to 30 minutes.
Okay. And did you use I think you mentioned before you used any records, charts, or other test results as it relates to the evaluation?
I reviewed the available records. I speak with the residential providers.
And what do the records include? Is that just the records of her treatment over time, or what records are you looking at?
That includes DBHDD records. That includes the forensic community coordinator records.
Okay.
That includes the medication list.
Okay.
I had worked in places doing free work almost just like 20 or 30 hours a week. And
based on your inspection and examination of Ms. Lovejoy, based on what you are required to do per the statute, as it relates to outpatient civil commitment, what is your opinion as it relates to Ms. Lovejoy remaining in outpatient civil commitment?
My opinion is that she continues to meet criteria for outpatient civil commitment due to her history of trying to get her medications regularly decreased, due to her history of routinely telling residential staff she doesn't need to be on medication, she doesn't want to be on medication, and her specifically telling me that she doesn't get any benefit out of taking medication. She believes she's over-medicated and that she'll be fine without any medication.
I'll take the medication, but so much of it I can't take all of it.
Okay, hold on, Ms. Lovejoy. There'll be a time when Ms. Reinhart may ask you some questions, or I may, but until then, we need to listen to Dr. Shores, okay?
All right.
Thank you. Back to you, Ms. Sellers.
Thank you, Your Honor. And let me ask you about Charlton home, the Charlton home. Can Miss Lovejoy, can she have visitors at the Charlton home?
Yes.
Okay. And she goes to day treatment. Is she allowed to visit? Can she visit people outside of going to day treatment? Could she, for example, go visit her daughter?
Yes, if she wanted to.
Okay.
Do you know if her daughter is local or is her daughter in New Mexico?
Florida.
Florida. Okay. And Ms. Reinhardt, I know you're not testifying, but is that her only child?
Yes.
So she has a daughter's in Florida. Got it. Okay.
And she can have visitors. Is that on a weekly basis, or how do you all, I don't know if you know or not, as it relates to the rules of the Charleston?
Charlton House. No S.
Like Charleston, South Carolina?
No S.
No S. Okay.
So the way it works is if Miss Lovejoy would like recurring visits, as has recently been approved for her to go visit a friend who's local, that's arranged with Charlton home staff. And if somebody is coming in from out of town and would like to visit with her, that's arranged through Charlton home staff as well.
Okay. All right. If Ms. Lovejoy would like to work, is she able to work?
Yes.
And would that be allowed at the Charlton home?
Yes.
Okay. Does Ms. Lovejoy work?
Not to the best of my knowledge.
All right. Nothing further, Your Honor.
All right. I got a couple more questions and then Ms. Reinhardt may have some redirect. So I'm still trying to sort out, Dr. Shores, if assume for a minute Ms. Lovejoy didn't move. So she says, I like the Charlton house, I'm going to stay here. But she gets a full release. And she starts to tell the staff at Charlton House, I'm not going to take, let me find your report. I'm going to do most of these medications, but that Clozaril, I don't like it. It tastes bad. It gives me a stomach ache. I'm done with the Clozaril. Who in Ms. Lovejoy's sphere of care would be able to say that's not optional? Would it be a doctor from the Oconee Center? Would it be someone at the Charlton House, or it would be no one because she's no longer on outpatient civil commitment?
It would be nobody.
If I don't change things, so Ms. Lovejoy stays in this good location, getting the good care she's getting, and she remains outpatient civilly committed, and she says, I'm not going to do this Clozaril anymore. Does that get brought to your attention or to Kelton Dutch's attention so that there could be an intervention? Or what would be different about Ms. Lovejoy declaring she's done with the medication if she's still under DBHDD supervision?
If she's still under DBHDD supervision and she decides she does not want to take medication anymore, Charlton House staff would work with her to encourage her to take the medication. If that didn't cut it, if she still didn't want to take it, they would notify the Oconee Center and see what could be done. If that doesn't do it, then Mr. Dutch and I get involved.
Okay. And if I were to end the civil commitment, that last step is gone. Charlton House would, of course, reach out to the Oconee Center saying, hey, we're really trying to work with Ms. Lovejoy on this Clozaril. She needs it. Here's the 19 good things it does for her. She's saying she's done. Oconee Center would do what they could, but ultimately it would be patient's choice.
Correct.
If Ms. Lovejoy, while under your supervision, meaning DBHDD, said, I'm not going to do it, ultimately you all could make a decision that it's no longer consistent with the level of care that she needs to stay at Charlton House. and she might need to go back into an inpatient setting because of the adverse effects of not taking the medication.
Yes.
And go ahead. No, go ahead.
I would like to say if she does get a full release and she's not under court order anymore, and she decides to stop taking her medication, Charlton House staff would still, try to work with her. And if she started to decompensate, they would pursue a 1013 for brief stabilization and further hospitalization if warranted.
Sure.
But come back to a DBHDD hospital for long-term treatment.
Okay, but we would break the continuity of care that has existed for these many years through the current DBHDD relationship with Ms. Lovejoy.
Yes.
Okay. All right. I'm just trying to understand the impact of full release versus where we are now. And it sounds like Ms. Lovejoy could stay right where she is if she wanted to, if she was granted full release. She also could find her own space, but continue to benefit from Oconee Center if she stayed in that county. And I'm understanding some of the levels of care that would only come in sort of in an emergency situation that we would lose if she were granted the full release. All right, that's helpful. Ms. Reinhardt, did you have any follow-up for Dr. Shores?
Yes, I did want to ask you, what about the crisis stabilization unit? Is there one there that they would have access to?
Yes.
Go ahead.
Yeah.
Okay. So would that be an option for the Charlton home if she decided to stop taking her meds and decompensated?
Yes.
And that would still be available to them without a court order?
Yes.
Okay, I have no further questions.
The crisis stabilization unit would be not a 1013 situation, but another entry in the continuum of care for Ms. Lovejoy if she got into a bad spot.
It would be, yes.
How is it different from a 1013 situation?
Crisis stabilization is very, very short term, whereas the 1013 can be longer term.
Okay. So it might be that very short term is exactly what one would need, and that's a resource that's there, but I shouldn't think of it as, oh, she could be there for a few weeks. Okay, got it. All right. Before Ms. Reinhardt, I see if you need anything else. Mr. Wright, good morning. If you've got a case with me today, it's not till 1.
Well, I was just getting ready to email Ms. Nelson to see is it by Zoom or in person? Because I'm out of Judge Eaton a little earlier than expected.
Let me just see who you got, and it depends. I'd say it depends where your client's going to be.
Anisha Smith.
She is due here at 1:30. It's plea and arraignment. Is she coming in person?
Well,
I remember her case now because we weren't sure if you were going to handle the case, and you are.
I've been in contact with her, and I can file a waiver if that'll.
Done. If you just fill that out and leave it with Deputy Gordon.
Sure.
Okay, great. All right, Ms. Reinhardt, back to you.
I have no further questions for Dr. Shores.
Okay, do you have any other witnesses?
I would like to call Ms. Jackson. She's she's in the picture, but she's the, well, I'll let her tell you who she is when you call her. She's at the Charlton home, so she can answer a lot of the questions I think that the court had.
Okay.
All right. Please, well, I guess we need to swear her in.
Yeah, Deputy Gordon's going to swear you. Which one is Ms. Jackson? Raise your hand. Right there. Okay, great.
You raise your right hand. Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State and spell your name for the record.
My name is Aja Jackson. It's OSJHAJACKSON.
Please, where are you currently employed?
I'm employed with DBHDD. I'm
And-
the house manager here at Emma's resident.
Okay. And how long have you worked with Ms. Lovejoy?
2 years.
Okay. And during that time period, has she been complying with taking her meds?
She has.
She has. And has she talked to you about a full release? Asking for a full release? And what is your understanding of what that would look like?
My understanding of full release would be she's no longer monitored by forensic services. She'll just be free of any supervision.
Okay. As far as day-to-day supervision, would anything change there at the house?
No.
Okay. And can you kind of give the court a general idea of her day-to-day there at the house? What kind of responsibilities or her daily activities?
Usually she goes to group around 7. She returns to the group home around 1. We do outings, shopping, out to eat. Most of the time she assists with the chores around the house, activities with her housemates, things like that.
Does she have a roommate?
She does. She has one roommate.
Okay. And how long has she had this current roommate?
I've been here 2 years, and since I've been here, they've been roommates.
Okay. All right. And does Ms. Lovejoy have visitors?
She does.
Can you tell the court who visits her?
She has one visitor, Mr. Scotty. He is her friend, her long-term friend.
Okay. Do you know about how long they've been friends?
It's been multiple years.
Okay. Okay. And what is he able to come and visit at the house, or how does that work?
Yes, he's able to come here, and she's also able to visit him at his residence.
Okay. And do you know if she has any goals or anything where he's concerned that is part of the equation?
The only thing she's stressed to me lately is that she wanted to do her visits with Scotty, have more days, and we have increased her days. That was the only thing that she's been stressing to me.
Okay. And is she able to have, like for instance, when her daughter comes, is she able to leave the house for any length of days, or is it just a couple of hours?
Yes, she's able to leave.
Okay. And what would be different if the court did grant a full release as far as Ms. Lovejoy's day-to-day activities?
She will resume the same activities. Day center, same thing.
Okay. Do you think that she would continue to take her meds?
I do not believe she would be as voluntary to take her meds.
Okay. And if she didn't, what would be your, what would you do at that point?
If she starts to decompensate, we will have to get her in some kind of stabilization treatment.
Okay. Would her bed still be held for her till she came out of that treatment, that stabilization?
Yes.
It would. Okay. How long has Ms. Lovejoy been there at the house?
She has been here since the house opened, I believe, in 2000.
'18?
Oh, in 2020 she came back.
Okay.
Oh, okay. Yeah, since 2020 she came back.
Okay. And has she been compliant with the rules and regulations there at the home in general?
In general, she has. It's been a few instances where she has not, but in general, she has.
What's an example of not complying with the rules?
One instance was, I think it was in 2021. She had a visit with her companion and consumed some alcohol while on the visit.
Okay. And has she been compliant since then?
Yes.
Okay. And she has visited with him since then as well?
Yes.
Okay. Are you, if Ms. Lovejoy wanted to step down, would you all be willing to help facilitate that? If, let's say if the judge actually granted a full release. And then down the road, she decided she wanted to step into another facility, something less restricted. Would you all help her or assist her in having that happen? Or how would she go about it? Okay. What about her case? Who's there at the house right now as far as job responsibilities? Case managers or who's there?
It's usually the staff, just the regular, I'm sorry, I can't even, house parents.
Okay. And how many people are there in a given day? Like during the day, 1 or 2?
It's usually 2 to 3 staff in the evening and 2 in the morning.
Okay. Okay. I have no further questions.
Ms. Jackson, I've got a few questions and then we'll see what Ms. Sellers has. If Ms. Lovejoy wants to see Mr. Scotty more often, is that something that can happen, or residents at Charlton House are limited to 3 visits a week or whatever the number is?
No, they're not limited. She can see him as much as possible, as much as she would like.
Okay. If she wanted to, is there a curfew? Sounds like a strong word for grown-ups, but is there a time when she needs to be back at Charlton House? So she goes on a Thursday to spend some time with Mr. Scotty and, it's 6 o'clock. I've got to be back.
Usually she's back at a reasonable hour, usually before 6 o'clock when it's dark.
Okay. And to get to see Mr. Scotty, does she just walk on over to his place? Does he come pick her up, or would staff deliver her?
Yes, the staff transports her.
Okay. And they know to pick her back up because she calls, or there is an understanding that we're going to come get you at 5:30?
Yes, it's an understanding. They usually both come up with the time, and then the staff let her know we'll be back at this time, and she's ready at that time.
Has Mr. Scotty largely been supportive of the work you all are doing to keep Ms. Lovejoy on point, taking medications, et cetera?
Yes.
Okay. You are actually employed by DBHDD?
Yes.
But you work at Charlton House?
Yes.
Is Ms. Lovejoy the only person you work with, or do you support other residents at the house?
There are 5 other residents at the house aside from Ms. Lovejoy.
Okay, and you support all 5?
Yes.
Okay. If Ms. Lovejoy were to stay at Charlton House, but were granted a full release, would you stop supporting her because she's not under DBHDD supervision, or you would because she still lives there?
I would still support her.
Okay. Are there any residents of Charlton House who are on full release, or are they all outpatient civil commitment?
There are some under full release.
And they stay there?
Yes.
Okay. Can they stay there as long as they want, or if you're on full release, you got 6 months and you got to find your own place?
They live here as long as they need to.
Is Charlton House full, or could you take 3 more people if they were in need?
We're full right now.
So you cannot take another resident patient until one of your 5 moves out?
Correct.
Okay. All right, Ms. Sellers?
Just only one question. Good morning, Ms. Jackson.
Good morning.
Does Ms. Lovejoy have the opportunity to have overnight visits?
She has not, no.
Can she?
With her family, yes.
With her family, okay. Nothing.
Can I ask one question?
He gonna get to you in a second. Oh, he gonna let you speak in a second.
Ms. Reinhardt, did you say you have one question?
I did want to ask, I want to follow up on the overnight. So if Miss Lovejoy wanted to, let's say, go on a vacation with Mr. Scotty, can she do that? Because go ahead.
We would have to, I believe, get meet with Dr. Shores and get some kind of approval.
Okay.
But the answer is not no way, never. It would be, that's an interesting idea. Let's explore whether that's something that would make sense.
Yes.
Okay. Has Ms. Lovejoy ever asked to either stay out longer one day or to go on a trip, and you all have shut her down saying, no, we don't do that?
No.
Okay. All right. Thank you.
I have no further questions.
All right. Thank you, Ms. Jackson.
You're welcome.
Ms. Reinhardt, any other witnesses?
Yeah, I think Ms. Lovejoy wants to address the court.
Yep. Ms. Lovejoy, I would like to hear from you. Make sure you speak clearly into the microphone so our court reporter can take down what you're saying, okay?
All I'm saying, I ain't got but one thing that I'm asking of courts and the group home here. My medication is too strong, and I asked for one pill to be reduced, and I got it reduced one time. And then this lady here, she arguing, like she was just gonna throw me around.
Yes.
And I took the medication, and it was fine, but she asked him to add more medication. She wasn't a doctor, and she didn't have to say something, tell him what to do. And he took it in stride, saying, well, I have to because of what she said. And I was the only one who had to like take the medication, and it makes me drunk and drowsy. I feel a mess in my head so far about 7 different times. Couldn't stand up because the medication was too strong.
Hey, Ms. Lovejoy, which one? I know one of the medicines you take is a shot, so that's not it. Do you know which pill it is that's making you feel that way?
Cosbane.
Which one?
Cosbane.
So I don't know. Does that have a different name? I've got you taking the close. Pardon me?
Is it
I'm sorry, Your Honor, Clozaril.
I take 200 milligrams of them, and he took 1 milligram off, and I was fine. The medicine worked fine, did miracles for me. And this young lady, she don't care for me too much. She gonna make a point about trying to take care of these people right here, because she just says she can do it because she take medication also. And he put me back on 100 milligrams of Clonidine, and I ain't been able to hardly stand up. I busted my head yesterday, Wednesday, Monday, and I couldn't stand up because I'd be so drowsy trying to get back on, get myself situated.
Emma?
I don't think I'm asking the court if they could reduce one of the pills, I would be fine.
Emma,
Just one pill, and I'll take the rest of the medication. I've never refused any of it. I took it. And I just busted my head and couldn't stand up, and I was drowsy and weak. And sometimes I feel like, if I think they let me be with some medication that I'm telling them this works for me, I would probably have no problem with some of the things that they're asking of me.
Emma, let me ask you a question. You wanted to ask the court for a full release today. Can you tell the court why?
Well, sometimes I feel like my whole life is just wasted away. And I don't feel like I want to waste away. And it's going on. I've never really fought anyone except they beat it on me. And I ain't never started a fight. And they beat up on me too bad. Sometimes I get beat up. And I walk away, and I walk away. And it's gonna have to come to some kind of stance that I either do or either I don't. I'm 75 years old, and I feel like I put in enough services. I might last part of my years and to enjoy life a little bit brighter than what it is.
Where would you go, Ms. Lovejoy? Do you have a place in mind?
Well, I get my own partners. I've had my own partner ever since my children was my daughter and I got like an income come in, and some people have told me where I can get an income because just receive the beats retroactive week and law. And I'm hoping I get a job and I can support myself. I really do feel like I'm strong enough to support myself and not just waste away this is my last golden years of my life, and I hope I don't have to spend it just without some care and people caring for me, because I feel like I'm able enough to care for myself. But the medication got me where they're saying that I don't take the meds. I take the meds, and one of the meds she took off, was so strong, and the pill was so strong that it knocked you out. And I took the meds, and I told him, I asked him would he just reduce some of it. He said he would reduce it. Then this lady said, hearsay, well, she don't care for me too much, but she's giving a hard time. And I've been drunk and drugged and drowned. And he said, he took the medicine and put it back on.
Okay, well, we'll certainly explore the medication situation. How long have you known Mr. Scotty?
Well, I've known Scotty's not going on 15 years.
How'd you meet him?
Yeah. I knew him from when I was growing up, and I recognized who he was, and he kind of recognized me, and then I just started talking to him, and we started just getting acquainted with each other.
You grew up in Milledgeville?
No, I grew up in Atlanta, Georgia.
And Mr. Scotty's originally from Atlanta?
He might be. We was kids when I had seen him.
Okay, but he's down in Milledgeville now?
Yes.
Okay, great.
He's doing well too.
Excellent. Ms. Reinhardt, did you have any other questions for Ms. Lovejoy?
No, Your Honor.
Ms. Sellers, did you have any questions for Ms. Lovejoy?
No, Your Honor.
All right, thank you, Ms. Lovejoy.
Thank you.
Dr. Shores, I've got a question for you. The Clozaril, I may be mispronouncing it. Is that a medication whose dosage can be adjusted, or you have to be at a certain level, or it's simply not going to have the needed effect, and we rely on the amantadine to try to cut the side effects?
Clozaril does come in standard doses.
Okay, but I mean, they have pill cutter. I'm not doing your job. I just don't know how that works. If I'm making it up, if Ms. Lovejoy is getting 100 milligrams, do doctors not, based on what she's describing, say, well, let's try 75 milligrams, or that's not how it works?
Not with Clozaril, no.
What is it about that you don't adjust it?
I'm not a medical doctor. That is a much better question for a medical doctor.
Okay.
It's psychiatric drug.
Okay. Would that be someone from the community service with the Oconee Center who would be able to engage Ms. Lovejoy on that?
It is. One thing I do want to say about Clozaril is it's a drug of last resort. It's used when everything else has failed, and it is, a lot of providers are very, very hesitant to prescribe a special certificate in order to be able to prescribe Clozaril. So this is not, there aren't substitutions for Clozaril.
Got it. We got here after a long journey.
Yes.
Got it. Understood. Okay. Thank you so much. Ms. Reinhardt, did you have any other witnesses you wanted to call?
I muted myself. Sorry about that. No, that's all we have, Your Honor.
Okay. Ms. Sellers, any witnesses you wanted to call?
No, Your Honor.
All right. Well, I appreciate you all sharing this information. Ms. Lovejoy, I hear what you're saying. You're still a young lady, but you feel like you've spent enough time in some of these places that you'd like to maybe be out on your own a little bit. I worry some that your support network in Milledgeville is kind of small outside of the community of care in which you live. Your daughter's down in Florida. You've got Mr. Scotty. But it also is pretty clear to me that you've done great work in stabilizing your situation. And this is not the Emma Lovejoy who got arrested way back in 91 or 92 for whatever happened. And I very much appreciate that. And I want you to enjoy as much freedom as is consistent with you being safe and folks around you being safe. I'll need to spend a little time thinking about what that right balance is. The good news is if I decide that it's not quite time yet for you to be on your own, we got to have this conversation all over again. My decisions are never, ever final. And we would see how things went a little bit longer and talk about it again. But it may be that now's the time for you to enjoy a different place and enjoy a little bit more freedom. So I will take all this under advisement. It would help me, Ms. Reinhart, if you would file, just, it can be very bare bones, but a motion seeking full release. You're going to know the statutes better than I don't know if it would be under 17-7-131 or 37-3-1 or both. But that will just be the thing to which I respond and enter the order, either extending the status quo or indicating that there ought to be a change.
Okay, I will, Your Honor.
Great. Dr. Shores, anything more we need to do I will enter an order that will either say, let's keep on going the way we're going, or it's going to say things change. And if it's a full release, I guess I just need to make sure I put in the right language that makes it clear that DBHDD can disengage from the situation.
If Your Honor does choose to let DBHDD disengage from the situation, just a simple, she is released from her NGRI status and DBHDD is released from involvement with her.
Okay.
We do ask, Your Honor, if you do choose to extend her civil commitment, we submitted an updated conditional release plan back in April along with the annual review. We would ask that be formally adopted in the court order.
Is that I'm gonna hold it up. It's a long table. Oh, and on the back it looks like even Ms. Lovejoy signed it, Mr. Dutch, you, all sorts of people signed it. Look, Ms. Jackson even signed it. So that's from April of this year.
Yeah.
All right, so if I am maintaining the status quo, I should formally adopt it. Any reason I should not actually make it Exhibit A to the order, or it contains sensitive information and we shouldn't put it in the docket?
We usually attach it to the order because they change, and so it's clear which conditional release plan she's under.
Okay, got it. And it's good to know that they are revised as time progresses. Okay, got it. Thank you.
Thank you, Your Honor.
All right, Ms. Sellers, anything else?
Nothing further from the state, Your Honor.
Well, thank you, everyone, in particular the folks at Charlton House for opening up your space so we could get Ms. Lovejoy on the call. Hope everyone down there with coughs gets better. And I will look for that just sort of very rudimentary motion for full release. And then I'll get an order out. How do we make sure it gets to DBHDD? Because I'll e-file it and it will go into the docket. So Ms. Reinhart will get it and Ms. Sellers will get it, but that's not a real impressive distribution list.
Yeah, and we have some issues with filing, which I'm going to have to try to tackle. When everything went digital after COVID, because we're statewide, we're not really part of the Fulton County system, and the case is so old that it's not really part of that. So that's kind of part of the reason why the way we file it, I mean, the way we get the hearing was we had to kind of ask. The real old cases are really not digital. So It's hard to try to, so I'm gonna have to figure out how to file that motion because we usually have to borrow someone else's information in Fulton County to file it.
Tell you what, I can make it easy. If you just email the PDF of your motion, I'll make sure it gets e-filed. Okay. Just copy Ms. Sellers on it. And what I'll do is whatever order I enter and e-file, I will make sure that I email a file stamped copy to both you and Ms. Sellers. Ms. Sellers, I don't know how she tracks all her cases, but I will email it to both of you if you will commit to getting it to Dr. Shores. I just don't have Dr. Shores' email address.
I'll get it to Dr. Shores and court services to make sure everyone.
Yeah, I actually have Mr. Dutch's email address on this release plan, so I can make sure at least that it gets to him. Good. We will take care of that.
Your Honor, it's my understanding that you email court services at DBHDD.
Yes.
And that they will distribute it to whoever needs it.
Oh, okay. So it's literally court services at dbhdd.ga.gov.
Yes, Your Honor. And it's on the very last page of the annual review we submitted, along with my email address as well.
Yeah, look, there's your email address. Oh, yeah, okay. In order to ensure, please send all court orders to, excellent. Got it. So you guys provide all the instructions if only we would read it. Got it. Okay, great. Thank you, everyone. Appreciate your time.
Thank you.
Your Honor.
Thank you, Judge.
Thank you, Dr. Barley.
Hey, nice meeting you, Ms. Lovejoy. You take care of yourself.
Mr. Judge Robert Barley.
All right.
Thank you.
You're welcome.
Listen.
All right. Well, thank you, Ms. Sellers. So Ms. Hall, I think you got the email. Ms. Abbasi is on her way, and she was on her way about an hour ago, so she should be here pretty soon. Mr. Peck is here. I've got the equipment for him, and we will work through a little bit of stuff. I just didn't want to miss the opportunity for him to be in court, see how he interacts with Ms. Abbasi, see how this equipment works. And if there are things we can cover, like the Jackson Deno or something like that, that would be great. I know you've been out until today. We lost Ms. Charles to a trial. I lost Mr. Shapiro, needed him, lost Ms. Charles. Everyone's in trial.
I think Ms. Charles is going to help today.
Okay.
Her case got continued.
Were you on, the email said you were on vacation, but I also know you were dealing with other stuff. Were you actually having some good downtime, or it was all?
It was a mixture. Still
Okay.
helping with my brother, but
Yeah.
I did get to take a couple days for
Good.
myself to
Excellent.
re-energize.
Well, then you're ready to go.
Yeah, I am.
I'm inquiring if they're gonna meet Price, because Price was not tried with it, but she is in the Fulton County Jail.
Oh, Ms. Price, we aren't going to go that far into things. So we'll cover, if we can, the Jackson Deno motion. It's good. I'm going to tell Mr. Peck that Price is here, because that has been, I think, one of the things that he and Ms. Abbasi have struggled with. Like, they're never going to get Ms. Price. Well, look who we have. So,
We have Ms. Price.
yeah. Okay. Thank you.
I'll thank Ms. Bond for that too.
Oh, you're welcome. I told you I was going to handle it.
I am impressed.
Yes, yes,
I heard she got here last night too.
yes, that's what I'm saying. Excellent.
Hey, Ms. Mann, I sent you a chat. If you want to take a break until 1, the last thing we've got on this morning's calendar is not going to be a plea. It'll be some combination of hearings, and we'll see what happens at 1.
Okay, will do. Thank you so much.
You bet.
Okay, see you later.
Oops. Are you here for the Peck case?
Yes, sir.
All right. Are you the Jackson Deno witness?
I believe so.
You hope so. Okay. Good. Sorry, we're waiting. His lawyer had to be in Coweta County first thing, but left a while ago. So hopefully it's getting real close. I may shoot an email out in just a second. But we will take care of that ideally this AM. All right, Ms. Hall, I will come out as soon as Ms. Abassi gets here.
Okay. I'll be here. How you doing?
Good.
I'm 88 Hall, so I'm working. Guess if this case goes to trial, I'll be the one trying it.
Yeah, I just had a previous case from 2017. Just a domestic case where I arrested when I was an officer, so I just talk about that. I mean, it's pretty cut and dry.
I don't know about this.
Oh,
Absolutely nothing.
you want mine? I got the,
Yeah.
oh, you got that.
Yeah, it's a lot.
It's not.
But Kay should be, I think she's gonna handle it. The one you
Yes.
probably talked to and all that. She was supposed to be in trial today. I've been gone for a week and a half, and before I left, I was on trial for almost 2 weeks. So, I know nothing. Oh, you know, I know the basics.
Yeah,
I don't
it's
know.
pretty cut dry. Like,
You were here for the Jackson Deno, so he made a statement.
I don't know. I haven't been told. They just like, hey, can you come talk about this? I was like, all right.
Okay. So what did you do
I was the arresting officer
for
the
Pamela Price, is the victim for you?
Carlo. Betsy
Oh, you're for the, you're here for the four. I think, let me see, you are Thursday? Yeah, you're here for the battery case. Okay.
What's he charged with now?
Right?
Hmm.
A couple cases, I think we have like 2 cases for rape. For him. Okay, so you're here for 4. We might do that today too, just because you're here to get it out the way. She's also gonna do that. I mean, and that is also simple. We're basically saying that in our current case, he's charged with rape, aggravated assault, false imprisonment, possession of firearm during the commission. In that case, he was charged with battery. So I guess we're gonna argue the aggravated assault and the battery, both family violence cases. Carlo, she here. She had a TPO out on him and he's still violated.
Oh, after the fact?
Oh,
Or during that
I told
time?
you, I don't know. Hold on, let me see. I don't know if it was before because her notes just says that
She probably got it after the fact. She
after
didn't
you
have it
got
lined up yet.
okay. So yeah. So she knows, she just got little bullet points in case I had to like wing it. So what I'm doing a lot of other stuff, but I literally just got back today from basically been gone for a month and a half. So I'm checking emails, I'm trying to like.
I know how that is. I just came back from a wedding and like a small vacation, so.
Yeah, I went to Panama, got black.
Yeah, well, I went to Destin, and then the wedding was in Jackson, Mississippi.
Okay, yeah, I went to Destin. I'm going to Destin in July. I need to tell these people I'm not going to go there and drive. It's the same day I'm gonna be out of town. It's not my fault. But I guess she had a different calendar for too, and then another courtroom here, so you may be sitting for a minute. If you want to give me your number, and I'm like, if you want to walk around, get something on the vending machine yet. I mean, I know you've been here since I've been here at 9. I think I've seen you. Because I think when he first gets back on the bench, you heard him, we're probably gonna do Jackson Deno. So I don't want you to sit here for like another hour, just like you're not doing nothing.
Yeah, so I'm supposed to start, I didn't supposed to start working till 12, so I'm going to
So you know, okay, well, chill then.
Yeah, I ain't.
I'm just, okay, cool.
Yeah.
I'm just trying to get caught up in life.
Cause I ain't even going back in, I'm gonna go change, then go.
Yeah.
I
Yeah,
gotta sit in traffic.
you definitely gotta sit in traffic.
So I was
Definitely,
like, I woke up, I was like, oh, traffic.
right.
People that do it every day.
Oh, I can't do it. That's why I said 8 minutes from my job. I can't do the
Yeah,
traffic.
I couldn't do it.
I can't, like,
Oh,
that's,
but well, my number's on here.
oh, well. Oh, you still got the same number?
Yeah.
This one's 733-1401?
Yeah.
Okay. All right. Well, if you disappear, I'll text you.
Okay, sounds good.
All right.
I'm a call man, but I was waiting. I don't know if I'll call him.
What's up? Hey, Mom. Mr. Nelson? I was not there. You wanna go around and see if we can go back?
Yes, please.
One of you guys let Miss Nelson know we're here, or should we just go all the way around?
I'm going back there now.
Thank you. Just let her know we're here.
That's like 4-4. People. 4-4.
Let's go to him.
Just to find out that. Yeah.
I didn't McBurney thought he
How's
was.
Mr. Payne doing back there?
He's all right.
Okay. He's not complaining too much. Yeah.
No.
Can you just holler at him? Your attorney's here. She's been here the last
Okay.
40 minutes talking to the prosecutor. And he'll be happy to hear that. I appreciate it.
That's it. I was like.
I've been here a while.
So you want to talk to her?
I will after talking to the judge. Although we may even break them out right now. I can do
Oh, him.
Yeah.
No, I'm saying that they're on Zoom. Was I send the emails earlier?
Right.
They're willing to come down.
Yeah, it's so many people. I was just like, which one was you? Which one? Which one was you? On YouTube.
I'm gonna go back and start talking to her, just let me know.
Yes. Yeah. So they're not, because I'm trying to change. And then he's saying that this doesn't have to make sure get control. This was I don't and so he could make yes. No, sorry. So when I was coming, the conversation.
Hey, how are you? I'll give you this before you bring him out. Is she back with her client? Okay. Got it. How goes your trial?
So we'll reset to the 12th of June.
Well, where you been? Poor Miss Hall's been sitting here all tense.
Outside talking to Mr. Bossy.
Oh, okay.
We're trying to see if there's any, not tense,
No, I'm kidding. Ms. Hall was very low key. We were dealing with a Ms. Sellers situation for a while. You were tense last night when you got the email?
So I didn't get any email.
I thought I included.
You probably sent the email. I've been sitting here taking emails this morning.
Oh, you've been catching up. You really were on vacation. You didn't check till this morning?
Right. I got back yesterday evening, but I wasn't handling the 413, so I was gonna watch. Which meant I could check my emails today.
Got it. And we're not going to do the 413. We'll do the Jackson Deno and also see if this equipment works. So were you standing there when the guy was talking about it? Yeah. So it's a normal laptop and the key is that the headphones should work.
Yeah, I have a lot of questions. When I was in that trial, I forget the name now.
Before you left, you were in the trial? Was it one of the consolidated criminal trial calendars? So it was with Judge Emerson?
Yeah, but it was on Judge Whitaker's calendar.
Oh, Jester? You did Jester? I didn't know that.
I just wasn't here for the second day of deliberations.
Okay.
I was already out, so.
Yeah, guilty. Life without parole. Judge Emerson doesn't joke around with sentences.
Yeah, I was saying, they were texting me, letting me know they had a question and some videos. And that was a really hard trial.
Well, it had been a mistrial before. I mean, it says that there's something complicated about
That too, so it was kind of like traumatizing going through it again.
it. Yeah.
But we made it through, so I have a lot of emails to catch up on.
I bet.
Both the password.
Is none. Is you type in admin and then just hit enter.
It's a lot of, who's doing what over the last few weeks.
In Mr. Peck's case, is the Jackson Deno, I'm printing out the motion now. It's filed in the 18 SC case, but I mean, whatever statement or statements he gave would be used in whichever case you go to trial on, whichever of you goes to trial.
So my understanding of Jackson Deno is the videos were put in the case of where the victim is Pamela Price. And that's the one we've been always trying to, if we were to go to trial, it would be that case.
So the 18 SC case, it says that in December 2017, officers responded to the Economy Hotel in Roswell. Defendant and alleged victim were in defendant's car. And some officers took Mr. Peck into custody and asked him questions. That's what they're saying is, but I'm wondering if he gave statements in, because he clearly got out on bond, because then there's another rape. Is there only a Jackson Deno in one of the cases?
Yes, sir.
Okay, and that's the one we're talking about.
That's what I'm talking about today. Yes.
Okay, let me see what's going on here.
Oh.
I don't think so, but let's see.
They get an emergency.
Hey, Miss Taylor, our calendar's not till 1 o'clock.
Okay, all right. Thank you.
See you then.
All right.
They may need to come in because it's saying it's not detecting audio, and that's of course the single most important part of the Zoom.
Okay, I'll take some.
Thanks. Did it work once you put the headphones in, or is it still saying no audio?
Computer audio. Is to microphone.
But the video's working, like you're in the Zoom. Okay. If you put the headphones on, can you hear anything? Hello? Hello? Oh, okay, let's bring them out.
Yes, both.
Mr. Peck, can you hear me?
Yes, Your Honor.
Do the headphones work?
Yes, they will. Yes, I can hear.
All right. Ms. Rivers, are you ready to go?
Yes, I am.
Great. We're going to get on the record in State versus Peck, P-E-C-K. Mr. Peck has 3 cases. And we're going to talk a little bit about where we've been and where we're going. And then I think we've got a witness here so that we could address the Jackson-Deno motion, assuming people have time for that. I do. We need to talk about a reasonable time to schedule. Is it 4:13? 4:13, the hearing on the 4:13, because Ms. Price is here. Ms. Price is not here physically in the bill. She is in the back?
I think so. She was brought over. She was booked in last night. I could just produce this morning.
Oh, okay. I had heard she wasn't brought over.
She's here, but she wasn't brought over.
Oh,
She's in
wow.
Fort County Jail.
Oh, the
Yeah.
email says she was in the breakfast.
But Ms. Nelson.
Okay.
No. Ms. Price is no longer in Kentucky. She is in the custody of the Fulton County Sheriff and will remain there until we try the case or do whatever else we need to do. But I wanted everyone to know that Ms. Price is here. She was supposed to be brought over this morning. There was a misconnect, but when we saw what time it was getting to be, because of your prior commitment, Ms. Abbasi, I made the executive decision, don't bring Ms. Price over. Let's use this officer's time, handle the Jackson-Deno and see where else we are. Because I have a 1 o'clock calendar. And so wouldn't be able to get to the 4:13 as well.
I apologize, Your Honor.
You went where we said you should go.
Yes. The conflict rules told me otherwise, but a young man who's been in for a long time was entitled to a bond, so it's
Yeah.
very important.
No, that was fine. We took care. We really only freed up about 20 minutes ago. So we're good.
Marina, before we proceed, maybe myself and Mr. Boston speak to you off the record.
Sure. Should we go to the jury room?
Yes, please.
Okay. I just want to make sure the equipment's working. So Mr. Peck says he can hear just fine. When I logged into Zoom, it gave me error messages about you don't have a speaker that's working. The audio wasn't working. And I thought, dang, that's the one thing we need to have working.
That's fine. I disabled it, so it'll cross the sheet.
Perfect. It remains disabled, but the headphones work just right.
Yes, you can hear just fine.
Yes.
Okay, excellent. Thank you. We're good. So we'll go to the jury room for, Mr. Peck's all right with that? We'll go to the jury room for 2 minutes.
It's just a place that's not.
Mr. Peck, I'm going to talk with your lawyer and one of the prosecutors in a room right there for about 3 minutes. They just have something they want to share with me that doesn't get broadcast all over the world. Then Ms. Abbasi will be right back and we're going to talk more about your case and hopefully have a hearing on this motion. Okay? All right, we'll be right back.
Your Honor, can I test one thing? If I speak into the microphone, Mr. Peck has said it's not picking it up. Can I sit on the witness stand and speak?
Sure, but one, your microphone's off.
Oh.
Just, there you go. Now you should be able to hear it.
Can you hear me through your headphones on that? Okay, never mind. We're good. I
Okay.
wanted to make sure he would be able to hear witnesses.
Yep. No, what was explained to me is that those headphones pick up anything through Zoom. So witness, you, if your microphone's on green, podium, and then if we're playing a video through the system or audio, he'll pick it up because he's on that same channel.
Perfect.
All right. Ms. Rivers, you ready to take something down, please?
I'm sorry.
Yes, I'm ready.
Great. Mr. Peck, I had a good conversation with your lawyer and with one of the prosecutors about scheduling. And we've agreed that we're not going to work through the state's motions today. There are two big motions. One has to do with the state's request to admit at trial, if you go to trial, evidence of other things you allegedly did. So when you go to trial, you're on trial for one thing. But if you did other things in your life that are similar to what you're charged with, under certain circumstances, I can allow in those other things. So the state could say, hey, he did it this other time, so maybe he did it this time, or this shows a motive, or whatever the state might argue under certain circumstances, I can allow that in. But your attorney wants to keep it out. And we were going to have a hearing. We were going to have a hearing today to do that, but we can't do that for a couple reasons. The other motion is that when you were arrested way back in December 2017 at that hotel in Roswell, you ended up talking to a bunch of different police officers, and the state wants to use some of those statements at your trial. I have to make a finding that you gave those statements voluntarily. If you gave the statement because the officer said, I'm going to lock you up for 1,000 years, or I'm going to take your kid away, or I'll give you $100 if you talk to me, that's not a valid statement. But if you spoke freely, the officer said, you don't have to talk to me, and you said, no, I'm going to talk to you, then the state can use the things you said to the police. But apparently you were real talkative that day, and you talked to a bunch of officers. So we need to work through all those, and that'll take a little while. So what we're going to do today, one we've already done, we confirm that that headset works for you.
Judge, it looks like that'll work for him to hear the witnesses. I will not be able to communicate with him at all during trial because he cannot hear me.
So we're going to work on that because we also have in the past used headsets. It would be a different headset, so we might need to swap them out.
Okay.
Where you and he can communicate over a headset.
But it's private from everybody else.
Correct. Back when we were coming out of COVID, the way we were doing things, because we had those, as if they made a difference, plexiglass barriers, you'd be at one end of the table with a headset that's only on the same frequency as the other headset.
Excellent.
And
Thank
you could say, hey, Mr. Peck, and he could hear you, and vice versa. But you also can send each other notes right now. But you're right. For him to hear you, you have to talk into the microphone, in which case I can hear you too.
Yes.
Two things are going to happen, hopefully, before we do this hearing I just talked about. One, you're going to meet with a doctor next week and cooperate with that doctor who's going to talk to you about your background and whether you had a head injury or anything like that. Will you talk with that doctor when he or she shows up?
Yes, Your Honor.
Great. The other thing is we're trying to get you hearing aids. Ms. Abbasi has put in a request, and I've signed something that has directed the county to get you hearing aids.
Thank you.
Well, you're welcome. Thank me when you get them. That's going slowly. We are coming up with ways for you to be able to hear what's going on in court without the hearing aids. So we may limp along with those headsets and then the other headsets I mentioned so that you and Ms. Abbasi can speak privately. You've been in jail for a long time, and I am very interested in, as I am sure you are as well, getting a resolution, whether that means it's a plea to these cases or it's a trial and a jury will decide guilty, not guilty, or maybe the state dismisses some things and you resolve other things. But we finally have a lawyer who is sticking with you until this is resolved. There's no more revolving lawyers. Ms. Abbasi is going to stay with it. I'm going to try to fix the revolving lawyer situation on the DA's side. But that's my project when we're done with this hearing. And we will reconvene this summer to talk about your statements you gave to the police and to talk about the state's interest in getting in these other alleged acts. I have a question, Ms. Charles or Ms. Hall. The 404B 413 notice is real old. It was filed by Ms. Jones Connor. And it only tries to get in that 2006 situation you've been talking about, and then a family violence battery. But of course, we've got an alleged rape that occurred after this notice was filed. And it may be that the family violence battery is probably this incident because it's transaction number 2, given that booking number. But the other alleged rape is not even included on the 413 notice because it occurred after the 413 notice was filed. If we go to trial on the Ms. Price case, and again, a reminder, Ms. Price is here now. We have Ms. Price and she can come in to testify. If we go forward with the Ms. Price case, would the 20 SC rape be a 413 scenario?
We talked about that, myself and Leah, whether we'll bring Ms. Bennett as well. We have to refile notice to include that, if we, when we next schedule, and I'll have Ms. Bennett available.
Yes, she would need to be here.
I'm not, I mean, whether she needs to be here or not, I can work through whether it's a proffer or not. She certainly need to testify before she testified at trial. But to my original question, the state will need to file an amended notice so that it's in the record. It sounds like it won't be a shocker to Ms. Abbasi, but the record ought to be clear that maybe there's 3 transactions, the 06 rape allegation with Ms. Kane, the 2017 family violence battery, which has been indicted with Ms. Carlo, and then the Ms. Bennett indicted rape situation. Okay, all right. I think I follow all that. So Mr. Peck, I just told you a whole bunch of stuff and you very patiently listened. Do you have any questions about what I just explained?
No.
So
Could you, just to make sure, could you let the judge know what he just explained? Yeah.
well, I'm gonna go over it. So you understand your next thing is you're gonna meet with that doctor next week, right?
Yes.
Okay, and then we're gonna get back together for a hearing and we're gonna talk about 2 motions. One of them relates to the things you supposedly said to the police. And what was the other motion? Do you remember?
No.
It's the one that has to do with that maybe you did some other acts and the state wants to let those other things in at trial. Okay?
Okay.
So those are the things we'll cover at that hearing. I just don't have a date for you quite yet. Okay?
All right.
All right. Mr. Peck, what floor do they have you housed on at the jail?
I'm on the 5th floor
5th floor?
Yeah.
How long you been there?
since I've been there.
The whole time? Have you changed cells at all?
I changed cells.
Okay. When was the last time you changed cells?
It's been a while.
It's been a while. Okay. How often do you get to go see the doctor there?
Not often.
Okay. Has anyone come to talk to you yet about the hearing aids?
Yeah.
Okay.
Did they come to you in the jail, or is it when they, is it when they came to you in the jail, or when they came and picked you up to go to Grady?
They talked to me in the jail.
Okay.
Yeah.
And did you also go to Grady to see a doctor?
Yeah.
Okay, good. Well, I'm glad you remember those things. All right, Ms. Abbasi, do you have anything else you want to get on the record while we have Mr. Peck here?
I don't believe so, Your Honor.
All right.
Just that we don't have any big objection to this
My
taking a little bit
understanding-
longer.
Sorry, I interrupted you. My understanding is that you have no objection at this point, as long as the evaluation is pending, to rescheduling this hearing.
Your Honor, for the record, I would jump up and down and scream and say, you should grant our motion on the 413 hearing because they've not met their burden. That's why I say no.
Okay.
We do not
Understood.
have an objection for more time to prepare our case.
Okay, got it. We will set a date for that hearing. And Mr. Peck, we're all going to see what the doctor says after he or she, is it a he or a she?
I believe it's the she.
Okay.
Is it a man or woman? You don't know?
He hasn't met with the doctor yet. It's
Oh, he-
next week.
He's met with the that other doctor, sorry,
Yeah.
hearing aids. You don't know whether it's a man or a woman? Okay.
No, the doctor who's coming next week.
Yeah, he doesn't know. I've told him everything about the doctor, but he's just clarity. I asked him if he knew whether it was a man or a woman.
Okay. The doctor who's coming next week is male or female? I'm asking you.
Female.
Female. Okay. So when she comes next week, you'll talk with her. We'll then hear what she has to say. And that will help us decide when we see you next and what we do. Okay.
Okay.
All right. Ms. Charles or Ms. Hall, anything you want to get on the record from the state?
No, Mr. Brown.
Okay, so we will continue this hearing that was set down to work through the state's 404B and 413 notice that we shifted late last night to work through the Jackson-Deno motion. Ms. Abbasi, do you have any other, well, you didn't file the 4B notice. That's pending. You filed the Jackson Deno, it's a motion to suppress. You filed that. Are there any other evidentiary motions that we ought to be teeing up for that day when we meet next?
I filed a motion to compel, which one request was I would needed Ms. Price's NCIC because I can only get the GCIC. I have that. It's a moot point.
Okay.
The second one is regarding the 413s with that 2016 incident. It was an arrest. He was not indicted. Deductively, there is exculpatory information in there in Mr. Peck's favor. And I've requested that. The state hasn't given it to me. They're looking for it. City of Alpharetta is looking for it. So that motion would stand. However, the state is aware of that. They are working on it as well. I assume going into that date, we will all know how that has resolved one way or another.
Okay, got it. Trying to think if there's anything else I want to get on the record. So we will continue this. We've got the Jackson Deno to hear, the 404B 413. NCIC is fixed for Ms. Price.
We know about the 4 DNAs that they found on Mrs. Price.
I don't know.
Well, can you ask?
Not today.
Okay.
Not today.
All right. Because the state know.
Not today.
You guys will be able to talk when we're done. There may be some things Ms. Abbasi doesn't want to have discussed out loud where we can all hear it, but just between the two of you. All right, I think we've covered it then. Thank you, everyone. Next time we meet, let's make sure we've got all the right people in place and we can go off the record. Ms. Rivers, we'll see you at 1 o'clock.
Is there anything else happening now? Can I keep him in the courtroom with the headphone on and show him a video? So he can hear the sound?
All right, it should be working again. Can you hear me?
Yes.
Great. We're up and running. So 1 o'clock
Yes.
ish?
Yeah.
Okay.
Okay, Mr. Peck. So can you hear through this microphone now?
Yeah.
Okay. Let me try and get the correct video.
How many people you got for the 6?
I think 4.
Come on.
So the total was coming in.
Come on. This is neither. And you can see that part up in your head. It is what it is. I'm gonna try to find the other one. I hope I.
That's just a picture. That's not a video.
Yes, it is.
What's the?
No, it sounds like a lot of basic stuff, but.
Hold on, I can turn it up for you.
But let's worry about getting you healed so you
This is
can
actually something I
continue.
do want to hear.
Suicide watch. I don't even know my training list. I hope he fucking dies right now the way I feel. But he's told me that he was gonna try to kill himself if he went back to jail. So just, you know, I don't even know why I said that. You know, I should need to get shit. I feel ready to get to me.
You need to worry about yourself right now, okay? Whatever has gone on in your personal life you deserve
No, I don't.
the best, okay?
No, I don't.
Yes, you do. I'm speaking.
All the shit I've done, all the lies, all the shit. I don't deserve anything. I really don't.
As a human being, you deserve to be treated like a human being, okay? You don't deserve to be stabbed. Nobody deserves to be stabbed. I know it sounds like a lot of basic stuff, but I know you're struggling right now, okay? You're in a lot of pain. But let's worry about getting you healed so you can continue healing, not just physically, but if you get what I'm saying, complete emotional healing and just overall. Because without, a sense of wholeness, healness, it's hard to make changes, okay?
Addiction.
What?
I've been fighting addiction.
I'm sorry. A lot of people do.
All right, I'm gonna show you the other one because this goes on. Mailed you transcripts of this. Have you gotten those? Have you gotten transcripts? I mailed you documents, which is the computer's best guess of what they say typed out.
Talking about photos?
No, what they're saying.
No.
Okay, those are in the mail and they're not perfect because the computer did it. I know this one, I requested a transcript. So you haven't even written down what it is she's saying. Let's see, 152.
What was this on the printed? 5/17/2018.
Because that's when the DA's office had it.
So they didn't have it before then?
Did I write down the wrong one? I guess not. They may have known about it. Where's that video?
Strange. Because in 2018, she was in another hospital.
She's here. So I'm gonna try and talk to her.
I mean, I'll go searching through it just like plain view, look around.
Is it earlier? Maybe it's earlier. Actually, it should be smack in the middle. There we go.
What is that you with? Where's the knife?
I'm gonna keep playing. It might be better. Can you see that one?
Can't see anything there.
And I can see it. Oh, well, it gets blurry when I stop it, so I'll play it back a couple times.
Can't see nothing on her forehead.
That huge dash right there.
Oh, okay. Let's see. Yeah, let's see it. Yep.
Yep, and you can see kind of the red on your chin.
You can see.
And you saw already, you're on this video at one point.
Okay.
They get CID. I'm sure they're gonna get CID. Yeah.
Okay. Are you all trying to go to lunch?
Yes.
Okay, so I can't talk to him now?
No.
Would I be, if I wait until after lunch, would I be able to talk to him or? Okay.
You'll be able to talk.
They're gonna take a lunch break. I can't remember how long it is. I'll sit around and wait and we'll talk more. Or would you rather I just, oh no, but we'll be in the back, right? We wouldn't be here able to watch the videos.
He said he can't come back at 1 o'clock.
Oh,
Oh, he's going back down.
Yeah.
okay. I'll schedule a visit with you or I'll come see it. come see you.
Yeah, because I do need to talk to you about some.
Absolutely.
important matters.
Absolutely. And like I said, those transcripts are in the mail. I don't know why you haven't gotten them yet.
Okay,
Okay? And this was for you.
okay, thank you. Thank you. Well, you have a wonderful day.
You too, Mr. Peck. Be
Very nice
safe.
suit.
Did you see the shoes though?
Oh, yeah, I like those.
Thank you.
Very sharp. Red bottom.
Exactly.
Yes. You got it going on. See you later.
Bye, Mr. Peck. For the love of God. Okay. But definitely talk to her and whatever her name is. So definitely talk to her and whatever her name is.
or rather comment. It was-
figured you ain't got something to turn 50 pages, man. Further, not me. That's I slammed that son of a bitch. I couldn't get my hand cut. My gun out that boy. I said, nah. Okay. Yeah, right, you know, so what you talking about? Why would I stay here to 1600? That's 9, bro, 13. That was 1 o'clock. Okay. All right. And Carl County Cleaning Officer got a peach to AC code now first. Damn.
You did what?
Then dog that. You must work part-time last night.
Mm-hmm.
Where you working at?
So everywhere.
Yeah, those say you work to get that money, man. But I hope he got cash, not that 1099. Be 1099?
Someone.
I hate that.
Man, no time to open the run.
Yeah, 30 minutes, man.
I come back and get the other end.
You just have sense that I was about to blow you up.
Couch in there?
Sorry?
Couch in there?
Do they? Oh my gosh. How nice.
On, what's tomorrow?
Oh, gosh. Yes, the trial calendar.
Yes. I was talking to Julian.
Yeah.
I was looking over, I'll let you get set up right now.
Okay.
Because do you have Mr. Kuntz?
That is gonna be Miss Feely's.
Okay.
There's multiple cases.
Right.
Right, okay, yeah.
3 of them.
Oh, is that on tomorrow's calendar?
Yeah.
Oh.
Tomorrow's 7th, yeah.
I did not realize that.
And then Everett Trapatis.
That was, yes.
He's Northwest. Okay, that was you.
Yes, that was me. When was your official switch into here?
Yesterday.
Oh, yay.
Yesterday, so I'm here. I am here.
Welcome.
Thank you. I'm ready to hit the ground running.
Yes.
Okay, so then I guess most of it's.
There's, do you have June 8th calendars with you by chance?
I did not let that one.
That's fine.
On my desk.
I know, Jasmine had like sent me some emails about them and I'm like, definitely haven't made it that far yet,
Yeah.
so.
Same. I was like, gonna catch up as we go.
Yes, absolutely.
Okay, so,
So then on today, let me see.
in arraignment.
Is this, are these yours?
Yes.
Okay.
This and a total, yeah.
Okay, and then, let's see, this one, Jordan Weather.
Yes.
So those three I'll have to do, and what about this? And that.
Yeah,
Plea?
yeah. That one.
Okay, cool, so let me write you down for that. I think those are be the only ones I have with you today.
Okay.
Let me check.
Why aren't any of these just simple ones?
No worries, thank you.
I think that'll go by pretty quickly. It's just playing arraignment.
What'd you say?
I said, I imagine today goes by pretty quickly. It's just
Oh,
playing arraignment.
yeah, yeah, it should be, I was just making sure, oh wait, there is. Do you have anything on this 1:30 calendar?
Well, I had this, number one.
Oh, yeah, what is going on?
I'm actually not sure. I was talking to Julian about it.
Why is that in our courtroom?
I don't know.
Because of all this other stuff, I'm like, can't we
Right.
have him assigned there?
Right, because there's 3 unindicted cases.
I mean, when I started working on it yesterday, I was like, I just didn't have the time, and I to track it down. So
And
hopefully
I
when
didn't-
Reeves comes, he'll take care of it.
Oh, will Reeves be here today?
Hopefully.
Okay.
If he's not in trial.
I didn't, I guess I should like look up this indicted case.
And then number two, it pretty much sounded just like status.
Yeah.
And then number
I
three
don't
is
anticipate anything happening about.
motion for bond. Yeah.
Okay, cool.
Well, it's gonna go back fast then.
Yes,
This is great.
speak it into existence.
Y'all have anything that, like Julie gave me like a, sorry, I use lunch to, you know, the gym over there on the fourth floor on the
Yeah.
center side, so I went over there because I'm trying to
Nice.
put some weight on, and I think I did too much, but so I.
Did you have something on this morning's calendar?
No, I came.
Okay.
And I sat here for about 30 minutes until I figured out, I was like, this is not gonna take until 1 o'clock.
Right.
I was like, Your Honor, could I excuse? Because sometimes judges, they'll start their calendars and they'll have the 1 o'clock, but they're pretty much gonna go.
Yes.
But it didn't seem like that was gonna be the case.
Right.
So, but I did come this morning. I
Okay.
wish I would have stayed for the motion, but tried to get some other stuff done.
Nice.
Yeah. Are there any, Julie kind of gave me a quick run through.
Mhm.
Is there any that you think are coming up? It's like, hey, can you give this one your quick once over, like something we can close? I love to close cases.
Okay.
So,
Here is,
I love to close on a plea and arraignment too, but I didn't see any that were an easy one today.
fully understand. There's a case, I will send you an email. It's on for 20th. So you
I saw
might
the
not-
calendar for the 21st, so there's one for the 20th.
Yeah, and I don't know if it came as like as an Outlook reminder, if it was like a separate email. I'm gonna send you an email though right now. Do you have your laptop?
Yeah.
Okay, I'll just I'll send you just like the case number.
Okay.
Oh wait, yeah, and I'll just put this one on your radar.
Okay.
Just because there's like a lot of history to it.
Okay.
But yes, let me type that up for you while I'm thinking about it.
We've got court, so we've got court every day except Thursday.
Wait, say that again?
Court today, court tomorrow, not Thursday,
I think we do have court Thursday.
then not Friday.
Yeah, I think that's right.
So not Friday.
Yes, that sounds right. Okay.
Mr. yourself on Saturday. Second row.
Yes, I went on, I worked from home because we're also trying to, next week is my last week in my house there.
Attorney Willingham, good morning.
Okay.
Hi, how are you? What's happening, brother? Man, I can't complain. I don't know. What's going on? I just got in here. Man, I drove down there, man. They hadn't started tearing it down. They did? They did the inside. Okay. They did the inside because I went up there to find the to see if I could just take a brick, but it hadn't started. How's it going?
Good.
Young peoples.
Good to meet you, Mr. Peoples. You work with the state?
Yes.
Oh, wow.
Who are you here for?
I am here for Damien Francis. I would love for you to consent for a bond.
Oof.
This is an easy one.
Damien Francis, I think that was that one.
It's on the 1:30 calendar.
Was that one with Julian Jordan?
Let me see who her name is. Because I've been sending. Thanks for that heads up, Mr. Peoples.
Say it again.
I said, thanks for that heads up, Mr. Peoples.
No problem.
This is a criminal count.
Yeah.
Yeah. I'm not going there. We're having hearing here for now. I'm just gonna
Cassie?
Okay, she'll be here.
She'll be here?
back.
Okay.
Yeah, it's just this and probation revocation.
Okay. Well, I'll be entertained for a minute. So thank you.
Gotcha.
So there's one at 1:30?
Yes, it's a probation revocation, which
I have
think
arraignment
is-
and bond.
yeah, you're at the-
Okay,
on the
yeah. All right.
last one.
Too bad it's not you.
I
I feel
know.
like you would consent.
I'm looking at that charge. I don't think I might have been a rough one.
It's so easy to charge molestation nowadays. Hard to get out of though.
Yeah, yeah.
Let me check on it. Can you check? See if he's here? He's not, okay.
See what happened last weekend?
Not this past one, the one before.
You checked out the bookstore?
It was closed. It was closed when I got there because they weren't open because it's the summertime. It wasn't open on Saturday. They close at 4 on the weekday. Do they? Yeah.
Jackets, I got a
See, oh yeah, they're gonna run your pockets. They're gonna run your pockets. I gotta reorder that that LeBron Nike jersey because I had the white one. The baby spilled something on it. But I think they're on sale now because when I bought it, it was like 120. And I think now it's like 60 something. Yep. So I gotta see. I'm gonna just tell them send you the bill. Tell them send you the bill. But yeah, man, it's nice up there. It's way better than when I was there. Hey, Julian. Man, we've got it covered now.
You sure?
No, not at all. Not at all.
I'm calling for Robbie. I'm ready.
Oh, okay. Yeah. I'm gonna talk to Lee when she gets here about Kuntz. Okay. See if we can hammer down a number.
Okay. Cool. As Rob probably hasn't said anything. Still in the trial.
No. But even if you hadn't,
August 12th.
August 12th? What is that?
Yeah.
August 12th. That's a Saturday. I'll be out there. My wife won't want to go.
I got it.
I saw they did all the planning committee stuff though. You didn't join
When?
for BL Day this year? I don't know when it was, but I've seen, they did all the fundraising stuff. Okay. Okay. Now, plea and arraignment in here, it goes by fast. Or is it like, because in Judge Richardson, he's on plea and arraignment, but also the cases where the scene was.
I've fun. I've missed so much, but please, if you haven't missed.
One calendar.
What did you, anything exciting while I was there? Did you go to?
Yesterday.
Okay.
I was digging into life. Judge Richardson.
Okay.
I was talking about for Leary.
Oh,
He's got his animator, so we can run a good-
I've been away for like 2 months. It was like literally 2 weeks. Okay, cool. That's good. Cool. Awesome. Were you here this spring? I was. Second trial. Yes. Okay. Charges. Cool. Okay. Awesome. Well, today, I was amazing. It was dreamy. I was just like, so.
This your ring come?
Because he says something like that, I talked to him earlier. I would have been 7, so it didn't make sense. I thought.
How are you?
I know. Exactly.
Oh, he was picking someone up from, okay.
That's me, sorry. Okay. That's fine, I still wrong. I'm happy to talk to you after the season call. This is an arraignment for me, so I will talk to you afterwards.
All right, good afternoon, everyone. Let me make sure we've got all the right folks on that. Yep, okay, great. We have several calendars this afternoon, plea and arraignment, which starts now, and then a mixed calendar that's at 1:30. So let's get going with the plea and arraignment. Position is to see if Ms. Taylor is on the call. Position 1 is, I'm going to mispronounce your first name, Vahensi Ross.
Pronounced it correctly, Judge. You got it.
Excellent. Where is Vahensi Ross?
Judge, he should be on the Zoom platform. Mr. Ross, you need to unmute your video and audio and announce yourself to the judge.
Vahensi Ross.
There you are. You're on the one that says Maine's phone?
Yes, sir.
Who's Maine?
You said what, sir?
Who is Maine?
My brother.
Okay. You borrowing his phone?
Yes, sir.
All right, great. Ms. Taylor, this is on for plea and arraignment. Mr. Ross is out on bond. Are you waiving arraignment? Does he want to be formally arraigned? What's the plan?
Judge, we waive formal arraignment and a reading of the charges. I believe we've had them already. I believe this case was transferred to you from non-complex.
That is correct because of one count. The fleeing and attempting to elude is a felony, and they don't have the authority to handle that felony charge. So we'll work together on this one.
All right. So, Judge, we would waive a formal reading of the indictment and enter a plea of not guilty at the time.
Okay. Mr. Ross, do you still live on Detroit Avenue?
Yes, sir.
Okay. I asked just to make sure that now that you're in my courtroom instead of where you were, we'll be sending notice out. Obviously, it'll go to Ms. Taylor, so she'll know, but we want to make sure it gets to you as well. So notices will get to your address. Ms. Taylor, I'm going to ask Ms. Nelson to coordinate with you to get that waiver of arraignment form. You know, we've got a form, but if you can get that filed, then I'll get a scheduling order out. Mr. Peoples will get discovery to you. You may already have some through non-complex, but he'll just make sure that if there's anything missing, that you get that, so you'll be good to go. Mr. Peoples, anything from the state on Mr. Ross's case?
No, Your Honor, everything you said is correct, and I'll double check about discovery. I had actually looked this morning, but I'll reach out to Attorney Taylor. There's nothing else.
Okay, so Mr. Ross, I will see you next, either because Ms. Taylor has filed a motion, like a motion to suppress or something, or you all have worked the case out, or it's time for trial. Do you have any questions about any of the things we talked about?
No, sir.
Okay. Ms. Taylor, anything else on behalf of Mr. Ross?
I just know if Mr. Peoples would put his number in the chat for me, I'd appreciate it.
Sure. He is the new line ADA in my division. So Mr. Jordan's actually sitting here in court smiling as things get handed off to Mr. Peoples. But Mr. Peoples can text you or send through chat his number and you'll be able to reach him.
Thank you, Judge.
I'm sending an email right now, Your Honor.
Okay, great. So Mr. Ross, you are free to go. Ms. Taylor, you should stick on because the next case is yours as well, I believe. Let's see if this person is here. The name is Derek Burke.
Judge, I don't have Mr. Burke. I don't know if he's present or not. The Burke mates, the name kind of sounds familiar, Judge. I may have some time ago done a bond hearing on the unindicted case. Not sure, but I've not had any communication with Mr. Burke. I got an email from you all about Mr. Burke from the state that asked that I represent him. I had not had any communication with Mr. Burke at all, Judge.
Okay, yeah, I'm looking. It was a minute ago, so I understand why you don't remember. In November of 21, you filed an entry of appearance back when it was unindicted. So it was just rattling around as a 20 CP case, excuse me. And he got a bond and now it has been indicted. So if that's the case you're rolling off, I guess you should file a motion to withdraw.
I will, Judge. I will. And I'll file a waiver on Mr. Ross. But I did try to make contact with the number that I had, the contact number I had with Mr. Burke, which was a family member, because like I said, I believe I got him a bond, but I was not able to reach out to them, Judge. So, okay. All right. Thank you.
Sounds good.
All right.
Ms. Willingham, is this your case?
That is going to be my case, Your Honor.
Okay, well, good afternoon to you. Bench warrant for Mr. Burke?
Yes, Your Honor.
All right. Position 3, and also on our supplemental plea and arraignment are Mr. James. He was on earlier, as was Ms. Luncheon. There's Ms. Luncheon. Let me get these off and do this. All right, Ms. Luncheon. And then is Mr. James is back on. Mr. James, can you start your video, please?
Hello.
Excellent. Let's add you to the mix. All right. Wow, you're pretty hard to see, but we got you there. Good afternoon, Ms. Luncheon.
Good afternoon, Judge.
You represent Mr. James in both his cases?
I do, Judge. I was appointed to these cases. I don't even know what year that was, but yes, I do represent. Yeah, it's been a while.
Excellent.
Yes.
Okay. One of them is a little more recent because it looks like it's a 23 booking number, but the other's been around for a little bit. Either way, are you waiving arraignment for Mr. James?
We are, Judge. We're going to waive arraignment and enter a plea of not guilty.
All right. If you would coordinate with Ms. Nelson to get a waiver of arraignment form that you could file in both those cases, then we'll get scheduling orders out. Mr. Peoples, will you make sure that discovery gets to Ms. Luncheon in the two cases?
Yes, Your Honor.
Excellent. Do you have Mr. Peoples' contact information, Ms. Luncheon?
I don't.
Okay, he's the new exciting guy on the block. So he's going to send you, and apparently he likes Green Lantern, one of the worst movies ever. But that's all right.
Absolutely.
The guy does have a cool ring. So Mr. Peoples will get you his contact info. You guys can start doing what you're going to do. Let me look up, Mr. James, your case to make sure we've got good contact info for you. It's like Ryan Reynolds in that. It was a terrible movie.
I hate that. I dislike Ryan Reynolds a lot.
Okay, well, I got nothing against him. He's hilarious as Deadpool.
Oh, the other movie, Deadpool's good.
Deadpool, he's very funny. Anyway, let's see. Mr. James, you still live on, are you in Stone Mountain?
Yes, sir.
On Braylorn Drive?
Yes, sir.
Great. Okay. Well, you'll get things in the mail telling you when you need to come to court. More importantly, make sure you stay in touch with Ms. Luncheon. She needs to be able to reach you, phone, text, however you connect with people, because she's going to start getting all the discovery in your case. One of your case has some kind of serious charges. So you're going to want to be available to her. She'll work with the prosecutor, and I will see you next, Mr. James, either because Ms. Luncheon has filed some motions that we need to argue, or because she's managed to work it out for you, or didn't work out and we'll have a trial. But either way, at some point, we'll be reconnecting. So you need to stay in touch with Ms. Luncheon. Do you have any questions, Mr. James?
No, sir.
Okay. Ms. Luncheon, anything else?
No, thank you, Judge.
All right. Mr. Peoples, anything from the state?
Nothing further, Your Honor.
Okay, great. You, Mr. James, you are free to go.
Okay, thank you.
You bet. And Ms. Luncheon, you are, if you have no other cases on here, you're free to go as well. When you say you were appointed, are you on our C3 list, our county C3 list?
No, Judge, I'm getting off of I actually am wrapping up all my criminal cases. So this is one of the last handful. So I am not on any list. I shouldn't be.
Okay, but you're gonna hang in there for Mr. James.
Yes, exactly. I'm keeping my obligation. So I'm gonna finish this case up.
What are you gonna do now?
I'm in personal injury now, Judge. So I actually have already taken a new position, but I've told them that, of course, I need to finish out this contract. So, yes. So,
good for you. Good luck with that transition.
Thank you, Judge.
All right, take care. Position 4 is Nicholas, and 5, Nicholas K. Is Nicholas K here? Hey, Mr. K. Hello, Ms. Wood.
Hello, Judge. How are you?
I'm well. You don't sound so well. You had a big event yesterday, or allergies, or come on up, Mr. K. You can just sit between the two lawyers.
Can Ms. Rivers hear me, or does she need me to stand at the podium?
I think if you just move that microphone near you, it was working well. There you go.
Thank you.
We're not taking anything down at this juncture anyway. So Mr. K is on for plea and arraignment. I don't think he has a bond in position 4. So you all should look that up. That's not to say he is out of jail on a no bond status. I think that's a direct indictment, and it rolled on in here without a bond. So I'm going to ask Mr. Peoples and Ms. Wood to work through that before Mr. K goes, just so that there's structure in place. And then the other, the burglary case, there is a very small bond in place. And I think that came to us from maybe non-complex because of these new charges. Assuming we sort out the bond situation, waiving arraignment?
We will waive on both cases. I believe I've already entered in my substitution of counsel. So yes, I'll get those waivers done and then I'll talk to Mr. Peoples about the bond situation.
Okay. Mr. K, I've got an address for you in Decula.
Yeah.
Did I say that correctly? On Harbins Road? Yes?
Yep.
Okay. Well, you'll get things in the mail at that address. More importantly, stay in touch with Ms. Wood. I'm gonna ask you to stay here while we sort out what to do with bond on your newer case. Do you have any questions about anything we talked about?
No.
Okay. Ms. Wood, anything else for Mr. K?
No, Your Honor, thank you.
Mr. Peoples, you have both cases?
Yes, Your Honor.
Great.
And I will work out the.
Yep. Okay. Then Mr. K, you can go back to the benches there, but please don't leave. We'll talk one more time. Position 6 is Jordan Weatherford. Jordan Weatherford is here. And I've got Jordan Singleton as your lawyer. Is that someone? That's Ms. Wood,
Yes, Judge. So
a woman of many names. All right. I don't have any notes on this one, so it looks like everything's in order. You've got a bond, et cetera. Is Mr. Weatherford waiving arraignment?
We'll waive, Judge. I do need him to stick around so I can get some updated contact information.
All right, sounds like a plan. We have consecutive indictment numbers. Mr. Weatherford, it's like this is an older set of charges. The address we've got for you is in Douglasville, Bronte Lane. You still there?
Yes, sir.
Okay. That's where we'll be sending mail. And Ms. Wood's going to get more contact information from you. You'll get a notice when you need to be back in court. Ms. Wood will get the discovery in the case, and she'll want to meet with you to go over that to better understand what all that means and if the state has a good case or a bad case, and you guys will develop a plan for moving forward. Is there anything from the state, Mr. Peoples, on Mr. Weatherford's case?
No, Your Honor.
All right. Mr. Weatherford, any questions?
No, sir.
All right. Well, you should go back to the benches. Don't leave until Ms. Wood says it's okay to go. She just needs to get a little more info from you.
Thank you, Judge.
You're welcome. Jacory Vaughn in custody. Okay. And Ms. Wood, special.
Bring on, Judge.
All right. Can we bring Mr. Vaughn out?
Yes, that's fine.
Okay. Do you need to use your radio to get your partner there? I see him. He just wasn't moving. Maybe if we did it over the radio. Hey, we need Vaughn. Shh, that's a 6. What is 63, person with gun?
You don't want to see.
I was just reading the police report and they did a 63 on some.
I'll tell you.
Okay, we'll go off the record on that. They were wrestling with some guy who had a gun and it was a 63. Okay. I don't want any of your numbers, to be clear. Keep them. Ms. Willingham, is this your case?
Yes, Your Honor.
Great.
And I didn't hear Ms. Woods' announcement. Did she say, please?
She said it's her case. It'd be great if she said plea. I haven't heard that word in a couple weeks now. I thought maybe you guys have forgotten that word.
Because I've been away, Judge.
Yep. Maybe tomorrow we'll hear it some. All right, we've got Mr. Vaughn in here. Good afternoon, Mr. Vaughn.
Good afternoon, Your Honor.
I'm Judge McBurney, And today is your arraignment date. You've been charged with a few crimes that Ms. Wood may have talked to you about. She'll be talking to you more. And all we're going to do today is figure out if you're entering a plea of not guilty, in which case your case will move forward. We'll get discovery to your lawyer, which would be the state's evidence. Then Ms. Wood will come talk to you about that and figure out what's going to happen next. Okay?
Sir.
Ms. Wood, is Mr. Vaughn waiving arraignment?
We will waive arraignment today, Judge. I have already filed my substitution of counsel.
Okay.
And I need to speak to him in the back after this.
Okay. So Mr. Vaughn, Ms. Willingham, who is a prosecutor, she's on the screen. She's not here in court, but she held her hand up right there. That's the prosecutor who has your case. She's going to get discovery to Ms. Wood. Then Ms. Wood will come see you to talk about the case. I will see you again either because Ms. Wood has filed some motion that needs to be heard, or you and Ms. Wood work the case out with Ms. Willingham, or it's time for a trial. One of those things will get you back here in court and we'll take care of whatever that is. Do you have any questions?
Okay, well then, no, sir.
You're going to save them for Ms. Wood? Okay. So the deputies will keep you up here and Ms. Wood will be back there. We are almost done with this calendar. And then she'll come back to talk to you. Okay. All right. I think that's it. Ms. Willingham, anything from the state?
Nothing, Your Honor.
Okay. Thank you. Well, we're on a roll other than one bench warrant. Waive and schedule. Waive and schedule. Next is Danette Cleat. Let's look up. This case. So Ms. Cleat is not here. This is a March 2020. Ms. Cleat allegedly hit someone with a stick, but is charged as aggravated assault. This is a complaint room special. So let me see. An apartment on Old National Highway in 2020, in March of 2020. So 3 years and 2 months ago. All right. So she's not here. Mr. Peoples.
Your Honor, they will move for bench warrant, law forfeiture subject to notice.
Okay. Ms. Feely. This may not be your case, but Ms. Wood's busy right now.
Certainly. We would ask for an opportunity to have a notice reset and have my office try to reach out to her, given the extraordinary length of time between the arrest and now.
So we'll do one reset for that purpose. I'm sure notice got sent to that address. Query, is that the right address? There's a second address actually. Oh, there's a second address that is a shelter, I think, in in Odyssey. But we'll send one out to the current address. Your office can maybe see if they can track Ms. Cleat down, and we'll go from there. All right, Tobias Slade.
He's in custody. He's mine. I saw him last week and filed a waiver. I'm happy to talk with him, or the court can bring him out.
No, if you've already filed a waiver, I mean, he can come to the, I don't want him to wonder why he got brought over here. So why don't we just bring him to the door?
And that case is going to be mine, Your Honor.
Okay. Are you Mr. Slade? Hey, I'm Judge McBurney. Your lawyer, Ms. Feely, was just letting me know that she has already filed a waiver of arraignment on your part, where she entered a plea of not guilty, indicated to the prosecutor, who actually is on Zoom, that she is ready for discovery. So the prosecutor is going to get discovery to Ms. Feely. She'll come visit you, and you'll get to see what kind of evidence the state has. I will see you again, either because Ms. Feely has filed motions on your behalf, or you all have worked the case out, or it's time for a trial. You have any questions about what's going on? Okay. Then Ms. Feely will be out there to see you once she gets that discovery, and I will see you once you and Ms. Feely decide what you're going to do next. All right? Ms. Willingham, did you have anything else?
No, Your Honor.
Okay. Mr. Slade has 2 CP cases listed there. One was dismissed. The magistrate did not find probable cause for the case ending in 947, but the 945 is still rattling around as you all are figuring out what you're going to do next.
I will look into those.
Juan Edwards. So this is an August 2020 incident, but Mr. Edwards has an active warrant out of state court. So I will entertain a motion for a bench warrant.
You want to say we move for bench warrant and bond forfeiture subject to this?
And his warrant is pretty fresh out of Judge Besson's courtroom. So he has been interacting with the criminal justice system much more recently than August 2020. Okay. I don't know that ever hit the public defender's radar, position 10. Again, this happened forever ago. It doesn't even list Eric Cho. It's often a sign that a long time ago there was some first appearance. All right, bench warrant. That is all I have for our 1 o'clock calendar. Is Ms. Clark talking to us? Nope, just got quiet. Okay. And I only have three cases on the next calendar, but it's about time to start it, so we can do that. Calvin Bailey, Mr. Hiles isn't here. Is he going to be coming? He's not late yet. We're a little ahead of schedule.
No, Your Honor, I think previously this was reset just so I could speak to him about his recommendation, given the original charges being of gang activity. We have spoken since then, and the state is willing to move forward with their recommendation.
Okay. Ms. Feely, are you ready to go forward on Mr. Bailey?
I need to speak with him briefly, but then we will be ready.
Okay, we will do that. Position 2, Ms. Smith, are you here? You don't need to be here. Mr. Wright showed up this morning and waived arraignment for Ms. Smith. He confirmed he does represent her. Is this your case, Ms. Willingham, or is this Mr. Peoples?
Judge, let's look and see.
Don't all run and jump at once.
I'm checking right now, Your Honor.
All right.
It's gonna be me, Your Honor.
Okay, great. So Derek Wright is your counterpart. He's in. And then the last position is Damian Francis.
Perfect timing, Judge. Good afternoon.
Hey, how are you?
Attorney Sandra Floyd for Mr. Francis. He is in custody, Judge.
He is. And we're going to have a bond hearing. We're going to handle Mr. Bailey. Oh, well, I guess you could talk with Mr. Bailey while we do Mr. Francis's case, if we have a prosecutor here for that.
That's gonna be my case, Your Honor, covering for 88 voucher here.
Okay.
Judge, can I have 2 minutes to speak with counsel?
Sure.
About a possible one.
No, that's not a problem. We have a lot of folks here. Are you all here for one of the cases I called, or are you here for other cases? Bailey? Francis?
Judge, I have some witnesses.
Okay, you can have as many people as you want. I just want to make sure if people were here, it's like, wait a minute, I didn't hear my case called. We could look up what it was, because the only 2 cases I've got left are Bailey and Francis. All right, why don't we take a little break? You can talk with Mr. K. You can speak with Mr. Bailey, Ms. Feely, and Ms. Fuller, you can talk with Mr. Francis. I'll come back out in about 5 minutes and we'll see what we're ready to do.
Oh, how I missed that.
I didn't see it either, sorry.
No, you're fine. Yeah, just toss it all out of the way. Because I think the reason is,
They gave him no bond on the more serious charges, but gave him bond on.
so, oh, I see, because there was a dismissal. And then there was indicted.
One more deputy for me. No,
No, perfect.
Okay.
See here.
One more person.
Bond denied for the following reasons: danger to the community, victim was severe offense. And so they gave him bond on some of the charges, but not on robbery. Or the
Okay.
So he's not on something, not everything.
So,
No, that's you.
That Martine?
Yeah. I'm gonna call you back. That's Martine. Yeah, I'm gonna call you back.
okay. Okay, perfect. Thank you.
Hey, let's do it. Can you do me a favor? Up to the GC.
There's no definite. Is he out?
Hey, how are you?
Thank you so much. Understood. That's good. GCS. Yes. Right. Because they know. So do I? Yeah. Correct that. Yeah. Yeah, that's what
Yeah, oh, it's okay. Relax at first.
Should I go back there? Thank you. Sorry.
Yeah, tell them I'm looking for that.
It's good. Okay, thank you so much. You are wonderful. It's good. True. She is telling us I don't want to give her up. Can't find the GCIC. She is. Amazing. Call her quick. I got you. Yes, ma'am. Thank you. Yes, that's the most recent. Yeah, actually. It looks like it was indicted last year, June of last year. He was indicted after this. The arrest date is. He was indicted. So that's not the same way to do and it's got the open facing career. Out here this year, MPJ, yeah. That's all the first time. Yeah. Yeah. When you get a moment, can we talk about tomorrow?
Sure, I brought that calendar so we can do just that. Let me talk to this one.
Okay, take your time.
family.
Take your time. It's great. But you're doing better than me.
Great.
Yes. That was the first time I looked at it. That would be
What kind of water may I see?
I don't see Ms. Feely. Should we do then Mr. Francis? Okay. So if you want to bring out Mr. Francis, Ms. Fuller, if you will come to council table.
Good afternoon, Your Honor.
How are you?
I am doing okay.
You look like you're doing medium. You're only one armed.
You know, Judge, and it is my dominant arm, so I am actually going to be entering this case with Ms. Fuller.
Great.
Co-counsel on it.
No, you come through. Come on.
Don't look, don't look.
Ms. Rivers, are you ready?
Yes, I'm ready. Can we make sure everyone's microphones are turned on, please?
Sure. And angled towards them. Great. Okay. Looks like we're good. This is 23 SC 187470, State versus Damian Francis. Mr. Francis is in court. Hello, Mr. Francis.
How are you doing, Your Honor?
I'm doing okay. Mr. Francis, we're going to do two things today. Today is your plea and arraignment date, so we're going to handle your arraignment. And then Ms. Fuller has filed a bond motion on your behalf, so we'll talk about bond. Those would be the two things. And the state will be represented for today by Mr. Jordan. Mr. Jordan, are you ready to go?
Yes, Your Honor, the state's ready.
Okay. Ms. Fuller, is Mr. Francis waiving arraignment?
Yes, Judge, we'll waive a formal reading of the indictment as well and ask for 10 additional days to file. And plead not guilty and ask for 10 additional days. We did file an opt-in to the discovery already, Judge.
Okay. There is a waiver of arraignment form, one of those 5. Deputy Gordon will bring it to you. If you don't mind filling that out, we'll get it filed, but that'll then be in the record as a waiver of arraignment. I will enter a scheduling order, which will actually give you more than 10 days to file motions, because the first deadline will be for the state to get you the discovery. Makes it easier to file motions if you've got the discovery. So there'll be a discovery deadline and then a motions deadline, and we'll go from there.
Thank you, Judge.
You bet. Mr. Francis, what we're going to do now is talk about bond. Ms. Fuller and others on your behalf are going to tell me why they think it makes sense for you to be out on bond. And then Mr. Jordan will have an opportunity to share his perspective. While I don't know that we'll hear from the alleged victim in this case, her family is also entitled to be heard as to whether they think bond is the right thing in this situation. So I may hear from 4 different groups, 2 sets of lawyers, and then 2 sets of advocates for each side. And then I'll let you know what's going to happen with bond. All right?
Yes, Your Honor.
Okay. When you're ready, Ms. Fuller.
I'm ready, Judge. Thank you, Judge. This matter started back in 2019, Your Honor, based on the indictment. The child molestation happened on July 12th of 2019. Mr. Francis was arrested this past February, actually February 5th of this year. So he's been in custody for the past 4 months without a bond. Judge, we're asking you to enter in a reasonable bond in this case. Mr. Francis, his family's here. He's a resident of the state of Florida at this time, but he lived in the state of Georgia from 2017 through 2020. During the times that he lived here, he worked. Prior to that, he served in the military. Mr. Francis served he served in Iraq and he served in Gulf War. I believe that was 2 tours that he served, and he was discharged honorably, Judge. But he does have anxiety PTSD disorder that he seeks private care for when he's home. He works full time, he provides for his family, and most importantly, Judge, he has little to no criminal history, never been charged with a felony. He works. He has his wife here, his mom here. He has people who will vouch for him. He went to high school and college. He did aviation maintenance tech, business administration, and general studies. This case, Judge, we're asking for a reasonable bond. I think Mr. Francis has some strong defenses to these allegations. And when the case is actually heard before Your Honor, there will be an opportunity for us to put forward either a motion to dismiss or a strong defense. The victim in this case lived with her mom, Mr. Francis, his wife, several people lived in the house together. And that was back in 2019. That's the same house they lived in back in 2017 through 2020. When they left to move to Florida. The allegations are that on July 12th, Mr. Francis molested Kayla, the minor child. That's a very specific date, Judge. And prior to that, subsequent to that time, the family continued to live together.
Help me so that the family unit would have been your client, Mr. Francis, and then he was involved with Ms. Russell's mother?
Yes, Judge. What happened was 2 families were living in the home.
Okay.
Mr. Francis, his family includes his wife and their child.
Okay.
Living with Ms. Russell's mother and their family. So 2 families are sharing the same.
Okay. So I didn't mean to get anyone upset by that. So Mr. Francis and his wife and child are one component of this household.
Correct.
And then the alleged victim and her mother and maybe someone else, that's another, just sort of not necessarily a duplex, but they're all sharing the same residence. Got it.
Correct, Judge.
Okay.
And they shared so well. They lived together, they ate together, they co-parented together. They did a lot together as a family. They hung out together. Miss Russell's mother is a cousin of Mr. Francis' wife. So they're sort of related in a sense.
All right. Okay, so they were all living in the same household, so they're effectively roommates. That would be the connection. And they continued to live in that same household all the way through 2020. Then Mr. Francis and his family moved to Florida. Where did the Russells go, if you know?
Russells stayed in the same home.
Okay.
They stayed in the same home. At some point in 2019, the DFACS got involved as a result of this case, and the police did some kind of investigation, Judge, and nothing happened. the families continue to coexist with each other. We have evidence to show that they hung out together, they celebrated together. They did a lot of celebration actually together. And Mr. Francis was always involved in every aspect of the relationship as they progressed throughout the year.
So there was, your understanding of the facts are that there was an outcry in 2019. It was investigated. No charges were brought. People continue to live together, celebrate together, whatnot. They go their separate ways. Fast forward 3 years, all of a sudden there's an indictment for the situation that is alleged to have occurred in July of 2019.
That is exactly correct, Judge. Miss Judy, the mother of the minor child, never reported this incident. When she actually reported was 2022, when there was some other family issue that came up because Mr. Francis was getting married, renewing his vows essentially to his wife. And then all of a sudden we have problems. This came up at that point. But no time prior to 2022 did Miss Judy contact the police. DFAX was involved. She had several avenues of where she could seek protection for the minor child, and she didn't feel compelled to do so, Your Honor.
Okay. So where would Mr. Francis live now? In Florida or in Georgia?
He lives in Florida.
But no, like if he is released, let's say I set a bond and he's able to make that bond, I'm going to want to designate an address where he stays. Don't know, I'm real excited about that address being not in Georgia.
We have someone that's close to the family. He's actually, Mr. Jett is here in court, Judge. He is a close family member and friend. He is willing to open his home to Mr. Francis or use that address for the court. But he is ready, willing, and able. He has a lot of family support here in Georgia as well.
Okay. All right.
But Judge, he does work in Florida. I guess he's missed a few months. He's been in custody since, but he was working full time. He provides for his family there. We would clearly prefer for him to be there, but he does have some connections to Georgia that would support him.
Okay. Anything else?
Judge, and we do recognize that the court has some time, limited time. So we do have witnesses here, Judge. I have Mr. Francis's wife, his mother, his stepfather, and his friends that live in Georgia, if you'd like to hear from them at some point.
I may. Why don't I hear from Mr. Jordan and see what the state's perspective is on this? And then if it ends up being something, I trust they would say, Mr. Francis is not a flight risk. He can stay with me. We'd like him home in Florida, which you've all represented. Okay. Mr. Jordan.
Thank you, Judge.
Before you do that, Ms. Hardy, good afternoon.
Good afternoon, Your Honor.
How are you?
Wonderful.
Great. What criminal history information do you have for Mr. Francis?
Mr. Francis has 2 arrest cycles, one in Georgia and one in Texas. No felony convictions, FTAs, or probation violations.
How old is the Texas arrest?
2009.
All right. Thank you so much.
No problem.
Mr. Jordan.
Your Honor, the state would respectfully request that you deny bond for Mr. Francis. The state has a slightly different rendition from counsel for Mr. Francis. There was an allegation of inappropriate touching of a 12-year-old victim in 2019. Where the state's version differs is that Miss Judy, whom is on the Zoom hearing right now, and Mr. Russell is the father, I believe, of the victim. When the initial report happened in 2019, they came together as a family and tried to handle the matter internally as a family and decided not to move forward with pursuing charges regarding the inappropriate touching.
Sure. But when you say came together as a family, meaning Ms. Judy and Mr. Russell and their daughter decided, or they also were having discussions with the Francis family, as in, you need to stay away from my daughter, I'll stay away from your daughter. Okay, as long as you can maintain your distance, we're not going to go. I'm trying to understand if it was kept solely within the Russell Judy, or if it was acknowledged, hey, Mr. Francis, don't ever do that again.
Your Honor, they either I know Mr. Russell wants to give a statement if.
Okay, he can tell us.
Yes.
He was
Your Honor,
there, you weren't.
Just so that we're clear, that the court is clear on the facts here.
Okay.
That they handled the matter internally, and that they decided not to come and pursue charges. In 2022, what made the case, and my apologies, Your Honor, if I may backtrack, the family decided that it was just best to keep Mr. Francis away from the victim as much as possible. In 2022, long after Mr. Francis had apparently moved out, Mr. Francis contacted, or someone that they believed to be Mr. Francis contacted the juvenile victim, and that is what made Miss Judy go to the police department with her 15-year-old now daughter, or 15 at the time, year-old daughter, to report the incident and move forward with the charges, Your Honor. Your Honor, one of the state's concerns here, looking at the Ayala factors, is that Mr. Francis, his GCIC indicates that he is a Florida resident. I believe that he was taken into custody here in Georgia just because he was here visiting friends, I believe, according to one of the reports that I read. So the state would contend that he does have connections and ties to another state and another community. And Your Honor, just because of the nature of this, I know it may be very difficult on this, since this is a family matter, that there is a risk of intimidating witnesses just because of the nature of the allegations and how the family did not proceed forward in 2019 because of internal pressure from the rest of the family. Your Honor, we would just request that you would deny bond for Mr. Francis. I can proceed forward. Mr. Russell wanted to give a statement. I'm not sure if Miss Judy wanted to give a statement or not, but I know that Mr. Russell wanted to give a statement in regards to bond.
Okay. Mr. Russell, good afternoon. I'm Judge McBurney. Why don't you share with us, please, what you want to share? I'm going to make you big on the screen there.
Good afternoon.
Good afternoon.
Your Honor, my name is the victim's father. And at the time it happened, the first time it happened, we with Mr. Francis and his wife, and we came to an agreement, you know, it's internal. Let's deal with it as a family. Leave it at it. We're going to take care of it as a family. So that we agreed to that. Now, wife is in the house with my daughter, Mr. Francis, and his wife, and their two kids. I live.
So, Mr. Russell, you're sort of cutting in and out. I don't know what's happening with the audio. We're getting like every third word of what you say. Is there another way you can?
Thing on here. Give me 1 second. Let me use another device.
Okay.
Is that okay?
That's fine. We'll sit tight. Miss Judy, while we're waiting for Mr. Russell to reconnect, is there anything that you want to share?
Yes, can you guys hear me?
We can. That's much better.
Hi, how are you? My name is Louise Judy. I am Kayla Russell's mom. I am O'Neill Russell's ex-wife. And I wasn't going to speak today. I was going to let Kayla Russell's dad speak, but I do need to speak up because the information that the other party gave was incorrect. So just to give you highlights, we all live together as a family. My cousin is my first cousin. We're a very close family. They resided in Florida. They reached out to me because they needed a place to stay. I live in a 5-bedroom home along with my daughter, and we were so close, there was no problem why they couldn't move in. I took in a family of 4 on top of myself and my daughter. We're now a family of 6. The first incident that transpired in 2019 was an incident where my daughter reached out to me to say that she was uncomfortable with a situation that occurred in the home. And when I want to be very clear, when I say uncomfortable, she was in a room watching TV. He came inside her room, laid in the bed next to her when we had made clear instructions that he was not to go upstairs because there was nothing for him upstairs, but my cousin and I were not home. So we did sit down and have a conversation to understand what happened. And hey, she's a young lady. You're not to go in her room. We're going to keep distance. My cousin and I made arrangements where we would never be out of the home. If she's out, I'm in. If she's in, I'm out. That's what we mean by we made. However, my daughter feeling left out because when we made those arrangements, he no longer spoke to my daughter in the house. She felt left out. She went to school, spoke to a counselor, explained the situation. The school launched an investigation, a full-blown investigation, sent the police over. DFACS was involved, yes. At that point, we made a family understanding that, okay, we talked as a family, everything is good. The defendant, Mr. Damien and his wife were moving to Orlando because after staying with me for 2 years and going to school, he found employment in Orlando. So he was scheduled to move to Orlando. The day they were moving, we had a family barbecue to wish them well. The day he was leaving is the day that my daughter was molested in my home and she spoke up. That same night he left, fled to Orlando to his parents' house. The next morning, his wife followed. At that point, we did not press charges because they moved out and the whole family, when they heard what happened, pressured me into saying, that's your cousin's husband. You don't want to do that. You're going to ruin his life. You're going to do this. At that point, Mr. Russell and I decided, do we want to put Kayla through this? Now that he moved to Orlando, we changed the locks. We did what we were supposed to do. 2 years later, Mr. Damien, after we told them, stay away from my daughter, you moved to Orlando, we did what we had to do. She removed his number out of his phone. We all did what we needed to do. He reached out to my daughter on her phone at 5 o'clock in the morning. At that point, she didn't realize it was him until she clicked on the number and his picture appeared. I went back into my phone to make sure that that was really him. And it was the same number, it was him. So we reached out to the family saying, why would you, after all that happened, after all the trauma and everything she went through, why are you still contacting my daughter? At that point, Mr. Russell and I felt that our daughter needed to move on, to heal, to be left alone. And clearly, he was not remorseful for what he did. The whole family was divided. His family and his spouse still to this day don't want to understand that this man is sick and has a problem. So we went to the authorities. They took my daughter's phone. They did a full investigation, interviewed her, did everything. This is why we pressed charges, because 2 years later, he reached out to my daughter. That's what happened. That's why. And right now we're a family. We're still family. No matter if that happened, his wife is my first cousin. The whole entire is divided. There's intimidation. So of course I fear for my safety and my daughter's safety, because till this day, they're not taking any accountability. So many people have come up in the family, friends and family, to speak of Mr. Damien Francis' character, of inappropriate behavior with family members and friends.
I'm going to object to any testimony from anyone that's not available for cross-examination.
What I'm saying.
So Ms. Judy, just let's stick to the situation that your family went through. And it's not testimony, but I hear your concern.
I understand. I'm just saying the same way they're saying that he has advocates that are speaking on his behalf of his character. I'm just referencing to, as far as the family is concerned, Your Honor, understand that if it was just my daughter, I'm just saying, even within the family. So now the family understand, and because Your Honor, understand the day that he fled, we could have called the police, and I'm leaving with that guilt, and I will have that guilt for the rest of my life. But her father and I thought we were doing right and not have her all involved again with police and everything. And they had moved to Orlando and we changed our locks and we were trying to move on. But 2 years later, when he reached out to my daughter on her phone, it made us realize that Mr. Francis not only was not remorseful, he's just sick. Why would you reach out to her again after all this time? And when we reached out to the family, they try to tell us, oh, it wasn't him, that my husband and I fabricated it. Why would we put our daughter through this all over again? I'm sorry, Your Honor, I'm very emotional, as you can imagine. My daughter is now 16, but when this occurred, she was 12. So this is what I have to say. And I want to move on with my daughter and I. But again, we are a close family. And the reason why he was apprehended is because he was visiting in Atlanta. My ex-husband, Kayla's dad, saw a flyer that showed that he was performing in Georgia, and that's how he was apprehended. Because the whole time he was in Orlando, nothing we could do in Georgia because we didn't have an address where he was in Orlando. And we didn't want to get the family involved as far as asking them what's the address because the family's already divided. But it took that long to apprehend him. And the only reason why he was apprehended is because he was visiting.
Okay, let me ask you a couple questions. One, you said he was performing. What is your understanding it is that Mr. Francis does?
He does rapping and music videos and things like that. So there was a show that was happening in Georgia. So there was a flyer that was posted to show where he was going to be, and he sings and he performs. He does that as well. So yes, he does. So he lived with me for 2 years. He does have friends in Georgia, but that was the purpose of him visiting, was to perform on that show. And he was apprehended before he even walked into the building, is what the police shared with us. So that's her dad was Kayla Russell's dad, who's on the line right now. He's the one that saw the flyer and was able to bring it to the authorities.
All right. Next question. The indictment alleges that Mr. Francis did something to your daughter on July 12th of 2019. I'm trying to follow the timeline you've given. Is that July 12th, 2019, the night where you're saying Mr. Francis went upstairs and lay in the bed next to your daughter? Or is July 12th, 2019, the day he did whatever he did, and then he took off for Orlando?
That is correct. The day that he laid in the bed next to my daughter, that was a year prior, and that's why DFACS got involved. I know you heard the statement. That's the reason why DFACS got involved, because when my daughter went to school and talked to a counselor, they felt that it was severe enough that you would go into the young girl's room and lay in the bed and make her feel uncomfortable. So they launched their own investigation. That's when, as a family, we decided that, okay, being that you did that, we're going to have a severe conversation so you understand that that's not appropriate. And my cousin and I took measures internally. That was that. But the day that we did the barbecue and that the molestation actually occurred was July 12th. That's when the next day he fled to Orlando.
Okay, I thought he didn't go to Orlando till 2020, but I'm following
so
that.
we're in 2023 right now. So it was 2019, I believe that it was 2019. I'm either 2019 or we're in 23 right now. No,
We
it
are.
was 2020 that July 12th that it happened. And then 2 years later would be 2022. Yes, it was 2020. You are correct, Your Honor.
I'm not correct or incorrect. I just was trying to follow the timeline. Okay. And your connection to Mr. Francis is that his wife is your first cousin.
She's my first cousin. And they both lived with me for 2 years, and we're first cousin, and we're like we were like sisters. Like the family was very close. So when she needed a place to stay, I didn't hesitate to open my home to her, him, and her two daughters.
Okay. And this family that you share, are they mostly in Florida or? Okay.
Yes. Her mom, everybody's in Florida, but my mom is in Canada, but most of the family is in Florida.
Okay. All right. Thank you so much for sharing that. Let me see if Mr. Russell's got better audio now.
Yes, I do.
Great.
Okay, so good afternoon, Your Honor. When this whole situation happened, my ex-wife had informed me about everything that went on. At first, I wasn't too happy about it because that's my daughter. And secondly, they told me, okay, well, we're going to handle it. It's going to be an internal thing. I said, okay, that's fine. Let's do it that way. I agreed to it reluctantly, but I said, okay, well, we're family. Let's handle it that way. Then again, in 2019, with this whole situation here that happened, I wasn't aware of it until after the fact that he had left, because I was very upset at what had happened to my daughter, to the point where I started looking, trying to find where he was. And that's how I found him on Facebook, because I was trying everything to know where he was, because you did something to my daughter, and I trusted you with my daughter in that house, and this is what you do. I was not happy about that at all. So when the opportunity arose, and I saw him performing here in Atlanta, I gave the information to the police officers. to go get him and have him arrested.
Got it. Okay. And do you, Mr. Russell, live in the Metro Atlanta area or are you somewhere else?
No, I live in the Metro Atlanta area. I actually, when this occurred, I stayed 5 minutes away from where my ex-wife is currently living. Now I live in Jonesboro.
Okay. All right. Well, I appreciate you sharing that. Mr. Jordan, anything else from the state?
Nothing further from the state.
Okay. Ms. Fuller, as the movant, I'll give you the last word. Anything you want to add beyond what you shared?
I do want to clarify a few things. First of all, Judge, might be a small issue, but Mr. Francis is just a part-time DJ. He had a full-time job working in Florida. And so he's a respectable member of society. There are a lot of discrepancies.
I want to be clear. I didn't say anything to suggest a musical performer wouldn't be. I just was trying to understand when Ms. Judy said, hey, he was performing somewhere. Does he juggle? Does he sing? Is he a comedian? And it sounds like you're saying he's a DJ. You can do whatever. Now, if he's going all over the country, that's a job-related concern we need to manage because on bond, he's not going to be going all over the country. But I appreciate your clarification.
Thank you, Judge. Judge, this is a very, the facts of this case are scattered. And even hearing Ms. Judy talk about the incident, the way Kayla told it to Ms. Okasha from the forensics department, the way the Officer Anderson, I believe it was, reported it, they're all different. All the incidents she refers to July 12, 2019, the first time this matter happened, as per the indictment, we still haven't gotten the discovery yet because we're just here. The case happened July 12th. Based on the evidence that we will present to the state, she was in Canada. Ms. Judy was in Dubai during this time. Subsequent to that, the minor child went to the school and said, my uncle Frank, she calls him her Uncle Frank, is not talking to me. Because he wasn't interacting with her, he's not talking to me, and she didn't have a relationship. The school felt that something was amiss, reported it. She didn't go to school and said she was touched. She didn't go to the school and said she was molested in any way. The DFACS got involved, spoke to Ms. Judy. Ms. Judy didn't pursue that. The police went to the house and investigated all the people that were living in the house and determined that there were no charges stemming from July 19th. Still don't know which date for sure, but the indictment says July 12th, but no one verified that July 12th something happened. And quite importantly, Judge, Mom, Miss Judy, we just heard from Mr. Russell, didn't tell him. Furthermore, she continued to have this very close relationship with Mr. Francis, with his wife, with his family. I don't know about anybody else, but this would have been severed if something credible had happened. But based on how Miss Judy conducted herself, her relationship with Mr. Francis, she quite honestly, Judge, didn't believe something happened.
So I don't want it, we don't need to argue it. This isn't about Ms. Judy thinking this or that. It's about whether Mr. Francis should be out on bail and what conditions would ensure that Mr. Francis comes to court, and equally important that he has nothing whatsoever to do with Ms. Judy, Mr. Russell, and their daughter.
And I was getting there, but I'm a little bit long-winded, Judge. But even the text message, which is we've seen a duplication of a text message that said young. He wasn't contacting the minor child. So we obviously, Judge, would agree that he has no contact with Ms. Judy, her daughter, Mr. Russell, whomever. He has no reason to, and he has not contacted them since July, I believe it was 2020. So especially for such a close family, Judge. He was found in Georgia. He's got family here. He has friends here. He's always ready, willing, and able. He lives in the same house as his mom. She's here. His stepdad is here. And they've been here several times, Judge, to vouch for him, just to support him. As you can see, they're here. His wife is a court reporter in the state of Florida. So the Judy family lives in South Florida. They don't live in the Orlando area. So they have no real reason to contact each other. Judge, we're asking that you put a reasonable bond, and we're asking for 5,000. And we're asking that Mr. Francis appear in court. We'll give you a local address, Your Honor, if you so require, but we're asking that you set a reasonable bond, no contact provision. Mr. Francis, just to be clear again, for the record, has no conviction whatsoever. He's never been convicted of a crime.
Okay, which means he also has never failed to appear in court for anything.
Thank you, Judge.
You bet. If Mr. Francis were to stay with, is it Mr. Jet? 1 T, 2 T's, 2 T's. What city do you live in? Lovejoy? All right. Ms. Judy, is your address anywhere near Lovejoy, Georgia?
I'm in Fulton County, sir, Your Honor, Camp Creek area.
Okay. And Mr. Russell, I think you said you moved to Jonesboro?
That's correct, Your Honor.
Okay. All right. Ms. Fuller, if Mr. Francis were staying in Florida, you said South Florida. Florida is very long. Where?
His family lives in Orlando.
His family, as in mom and dad or stepdad?
Stepdad, his wife, and himself live in Orlando.
Orlando. Okay. So Central Florida.
Central Florida.
All right. And Ms. Judy, your daughter still stays with you, or does she stay with Mr. Russell or in some third place?
She stays with me. I'm the custodian parent, but she's with her dad every other weekend.
Okay. Thank you. All right. Mr. Francis, I am going to set a bond for a couple reasons. One, you don't have a criminal history that suggests that you've been in trouble much before, which doesn't mean you didn't do this. I'm not deciding whether you did this or not. That's not what's before me. And this is obviously a real serious charge, but you haven't failed to show up anywhere. You clearly have support. And by that, I don't mean people who've convinced me you're a good guy or you didn't do this. That's not what I'm deciding today. But people who will get you here and make sure that you stay on point with this case. They are serious charges. They're also old charges. And I would be remiss if I ignored the fact that between July 2019 or 2020, whichever it turns out to be, and now, there are no allegations that you did anything like this. It does sound like you reached out to Ms. Russell, and whether we call it reaching out or not, it looks like the state has a text that you sent, and that kind of thing will just cause your bond to go away. If there is any contact between you and Ms. Russell, you and Ms. Judy, you and Mr. Russell, or anyone associated with you. And this may get complicated, but your wife can't reach out to Ms. Judy to say, what's going on? Why are we doing this? If Ms. Judy gets evidence to the state that someone on your behalf is contacting her, whether it's meant to be uplifting or not, if it's about her daughter, this situation, that outreach from your wife, your mom, your friend doesn't revoke their bond, it revokes your bond. I'm just letting you know now, if I get evidence that you or someone on your behalf has made any, other than your lawyers are free to contact potential witnesses in the case, but anyone else about your situation, that is other than getting arrested for something else, the quickest route to having no bond until your case is resolved. You have been away from your friends and family for 4 months now. That's got to have been very disruptive. And I'm guessing you don't want to have that happen anymore, other than whatever happens at the end of these criminal charges. So it is real important that you comply with that condition of no contact. It's not direct contact, as in you're doing it. It's not indirect contact. Folks on your behalf are doing it. And it doesn't mean you call someone. If someone is just posting on Instagram, like, who would think that Damian Francis would ever do something like that? And that Instagram is consumable. by Ms. Russell or her mother or her father, and they consume it and they get it to Mr. Jordan, that's going to revoke your bond. So this is just a dead topic for you. You talk about it with your lawyers. You don't talk about it with anyone else, because if you're conversating about it or your family's conversating about it is done in a public way on social media, and that drifts over to Mr. Russell or Ms. Judy, you have indirectly contacted them about this case, and you cannot do that.
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Okay. So I'm conflicted as to addresses, and I don't usually ask for input on this from the state's already said no bond, but in some ways, Orlando makes more sense, because then Mr. Francis is further away from Ms. Russell and Ms. Judy, et cetera. If he is in Lovejoy, he's closer to all the folks involved. So Florida is safer in that respect. And I'm not suggesting, Mr. Francis, that you're going to run out and go chop someone's head off. It's just, you are not going to bump into someone. If you're in Orlando, you're not going to go into the grocery store and bump into someone you need to not bump into. If you do, that's because they went to Orlando, and someone coming to you is not you violating the bond. But Florida is not Georgia. And if you get skittish, it's harder to get you back here. And so the value of you being in Georgia is I can get you to court if I need to. So, Mr. Jordan, your thoughts about Orlando, probably better for Ms. Judy and her daughter and Mr. Russell versus Lovejoy.
Your Honor, I know that one of the specific concerns of the parents here was that it was more or less contact towards them, the family, and specifically their daughter. I am conflicted as well about saying that Orlando would be the best place. I know when reviewing this case, looking at the Ayala factors, there's no FTAs in Mr. Francis's history, so.
He doesn't have, I don't think you could point to a reason other than, hey, there's serious charges, that would be a risk of flight. Other than Orlando, he's outside. It's an indirect way that we would get him back here.
Your Honor, just on its face, just because he still would be somewhere within the area, my initial push would be Lovejoy, just because it stays within the state of Georgia. But we will absolutely defer to the court on that.
All right, Ms. Judy, do you have a preference if I am going to set a bond for Mr. Francis? And I know you don't want that. I heard everything you said. Do you have a preference for your peace of mind and your daughter's peace of mind? That's really who I'm focused on the most. Whether you know that Mr. Francis's address is going to be in Orlando versus Lovejoy.
I don't know if her dad wants to speak on that. I know for me it's safety, and it would be better if he was in Orlando. I understand the logic behind that, but I just don't want any problem, because we also want peace of mind and we need closure. So I don't want problems with not coming back, or, you know, I'm conflicted. So
okay,
Taylor's dad answer the question.
Okay, no pressure, Mr. Russell. What are your thoughts?
Okay, so in relations to where I live, Lovejoy is 10 minutes away from where I stay. So Orlando would probably be better for him.
That's my thought. I didn't know where, I know where Lovejoy is only because there used to be a private prison where they held federal inmates. I think it's kind of near Jonesboro, and you're confirming that. That's a little too close for comfort.
I literally live 10 minutes away from that prison that you're talking about.
And I don't need you and Mr. Francis bumping into each other. So, all right.
Yeah, it'd be good for him.
No. Okay, that's helpful. Thank you. So, Mr. Francis, I am going to set a bond. There's only one count. I'm going to set it at $25,000. It will be you'll have to make that through a bonding company. I was going to do pretrial supervision, but it doesn't make sense to do that if you're going to be in Florida. I'm going to require you to live in Florida. I'll need that address because that's going to be on the bond. And if you're going to move, you got to get approval before you move. So whatever address is home in Orlando, that's it. And you need to stay out of Georgia except for coming to court. That's why you come to Georgia. So if your side gig of touring, like, hey, we got something going on in Columbus, Georgia, you don't, because you're not coming to Georgia. You can go to Texas, but you can't come to Georgia, other than when you need to come back here for court. And then the most important condition, and I won't go through all the details again, is that you will have no direct or indirect contact with Ms. Russell, that's Kayla, her mother, Ms. Judy, or her father, Mr. Russell. Your lawyers, like I said, are free to reach out to them, but not you, not your family, no one associated with you other than your lawyers and their investigators. Mr. Jordan, any other conditions?
Your Honor, I know this may be included within the contact provision, but no contact through social media as well. I apologize.
No, I mean, I'll repeat it, but the direct and indirect contact, direct would be you call, you text, you drop something on one of these three people's Facebook page, if you can do that. But also not indirect. And that's what I was saying, whereas you just post something. I'm not sending to anyone, but I'm putting on my Facebook page, I can't believe Kayla's lying on me. That is consumable by other people. And if it is consumed by Ms. Judy or Ms. Russell or Mr. Russell, and they screenshot it and it goes to Mr. Jordan, you've blown it. So you can post anything you want about anything other than this case and these three people. Okay?
Yes, Your Honor.
Does that confuse you in any way?
No, Your Honor.
Okay. All right. Anything else, Mr. Jordan? Ms. Fuller, anything else?
So do you want me to prepare the order or you?
I'll take care of it. I just need you to send to Ms. Nelson the address where Mr. Francis will be staying.
I could read it in the record right now if you want.
Works for me.
It's 10049 Black Walnut Court. That's Orlando, Florida, 32832. Is that correct, Mr. Francis?
Yes, ma'am.
10, the Florida addresses have so many numbers. 10049 Black Walnut Court, Orlando, Florida, 32832.
32832, correct.
Yeah. Okay. And that is the house where Mr. Francis and his wife live, or also his parent, like is one big. All right. So he just likes to live in big households. That's his thing. Okay.
They're close.
All right. Ms. Judy, do you have any questions about anything I've said?
No, Your Honor.
Okay. Mr. Russell, any questions?
None at this time, sir.
Okay. I appreciate both of you participating in this and sharing your perspective. It was important that I heard it. All right. That's what we'll do. Ms. Fuller, you'll be getting discovery, probably not from Mr. Jordan. He's sitting in for someone today, but from a prosecutor, and we'll move the case forward.
Thank you, Judge. Judge, I do have the waiver of arraignment form completed.
Great. You can bring that to me. Thanks. All right.
That's all we have, Judge. May we be excused?
Yes, ma'am.
Good seeing you again, Judge.
Same. All right, let's get Mr. Bailey out here, please. And what are we doing with poor Mr. Is it K? Yeah.
Just 1 second, Your Honor.
I just don't know. I mean, we need to give him a bond. I don't know if we need to give him a bond. We have to discuss bond, but Deputy Gordon was asking all the usual right questions, which is like, does he go into custody? And I don't think he goes into custody right now. But where are you trying to go?
I'm sorry, Judge, just to say something to Mr. Francis.
Oh, to your client. Okay.
I'm sorry.
Yeah, that's right. You go that way, you're not gonna find him.
I'm sorry, Judge.
We rarely bump into this process, and there's no warrant for him. So I don't think that was my response to Deputy Gordon was, yeah, it probably have to be booked in. Ultimately, I don't think you can just get a bond that falls from the sky. but it may end up being more on his terms, if that makes sense, because there's not a warrant unless you showed up with one I didn't know about.
We did not, Your Honor, and I have not come up on this specific issue prior, and you are correct, there is no warrant.
Right. I mean, so that what the sheriff's people would say is, how are we taking him into custody? And I could say that, but that's not enough. Believe it or not, I have to give him a piece of paper, and I don't have any piece of paper to give him because there's no warrant for him.
And I believe what we'll do, Your Honor, is file the appropriate paperwork that happened if that's what the state would decide to do, but we would not proceed at this time.
Okay.
Without that warrant.
But then Mr. K is wandering around with some serious charges with no bond, not meaning he's in no bond set. There's just a bond doesn't exist. There hasn't been, and that seems like the wrong setup too.
It does, Your Honor, and I understand the court's concern. I would ask that we hold them to the end. That way I can at least attempt to make contact with any victims and see what they would like as well.
Well,
before I make a recommendation of bond.
You don't have to do that now. I'm gonna let Mr. K go and ask you to put on your growing list of things to do, to think about bond. It may be the two of you can agree on a bond amount. If you don't, we'd need to have a hearing. But I just want to structure it so that when I say it's on Mr. K's terms, he obviously doesn't set his bond. I will do that. But because the state did not decide to get a grand jury warrant in connection with the direct indictment, if actually the two sides agree on a bond amount and Mr. K can make that bond amount, I would want him to be able to go to the jail and just be in and out. He's literally being processed. And this I've heard of happening where he does that, like people who have a bond on 4 counts when it's a CP and then they get indicted and there's a 5th count. There's a way for them to kind of round trip through the jail. They don't have to get taken into custody here. But you all can coordinate that. It's only if there's not, if you disagree, you may say $100,000 bond and Ms. Wood says, that's crazy talk. There's serious charges. Maybe that's the right amount. Then we would need to get a warrant and then have a hearing here and see that. You take the time you want, just know that there's someone charged with something pretty serious who is bondless right now.
Understood, Your Honor, and I think it's something that we'll attempt to have closed out before the end of the week.
Works for me. Mr. K, do you have any questions about that? Okay, stay in touch with Ms. Wood.
Thank you, Judge.
All right. All right, Ms. Rivers, you ready to do our last position?
Yes, Judge, I'm ready.
Great. We have Mr. Bailey here. It's 16 SC 146059, State versus Calvin Bailey. Mr. Bailey, you pled guilty to a gang charge and a burglary way back when. And in September of last year, I signed a warrant for your arrest because you allegedly violated your probation in August of last year by committing a new offense of entering auto, maybe having a credit card you shouldn't, in DeKalb County. And there were some technical violations as well. You were supposed to complete a class and you were supposed to be working in a way other than entering autos. So that's what got you here. Ms. Tucson, how much time remains on Mr. Bailey's probation in this case?
Give me one moment. I'm pulling that one back up.
Okay.
I have Bailey. Where is it? And we're talking about the one that we have on the calendar, 059.
Yes, if he has other cases, I guess we should work through them, but
No, that one expired.
okay.
Okay. Two years, 11 months, and 9 days. That's
All right.
Okay, I wrote down the wrong one. Yeah, the 16 SC 146059. 2 years, 11 months, and 9 days.
Got it. Thank you. Okay. Ms. Feely, you're handling this? Great. Is Mr. Bailey admitting to the allegations? Is he challenging them? What have you sorted out?
So we are admitting for purposes of probation, for purposes of this hearing, the allegations in the petition.
Okay, can you move the microphone towards you? Thanks. Okay. And it looks like Mr. Bailey's been in for over 6 months. He has an open case in front of Judge Edwards. I think he has a bond on it. It says jail, but that may be, this is the part of the jail. So if he resolves this, Judge Edwards's case may not be holding him in, but I don't know. I just see that that's there. And then there may be a new case out of DeKalb if this arrest in August resulted in anything. I don't know that status. Okay. And what are you recommending?
We are actually recommending the 6 months he's already served. He's got bonds on his new case, so he'll have to bond out and deal with those, but that's what he hopes to do. We just don't see that there's much point in him doing more time on just this revocation. His biggest concern, frankly, is his son Leighton turns 1 on July 20th. And so he hasn't seen him for quite some time at this point. But I'm happy to tell you more about Mr. Bailey at the appropriate time.
Okay. So you're recommending effectively time served?
Yes.
All right. Mr. Jordan.
And Your Honor, the state's recommendation for Mr. Bailey would be that he served 1 year. Of course, he get credit for the time that he's already been in custody. I have approximately 200 days for Mr. Bailey. I know that he's only on for this particular probation revocation regarding the DeKalb case. He does have 3 unindicted pending matters here and also has the case that Your Honor mentioned in Judge Edwards' courtroom that is indicted. It looks like that has a final plea scheduled for June 30th. So that is seems to be at least coming to a close or may potentially close at the end of this month. Your Honor, the state's recommendation would be that 1 year be revoked and then the balance be suspended, given the amount of infractions that Mr. Bailey has incurred. We don't believe that, or at least from the state's position, that probation would make sense at that juncture, given the amount of cases that Mr. Bailey has.
Yeah, so I see he's got 3 CP cases. Are any of them, I'm looking them up, but are any of them particularly serious? Are they entering auto type things? What?
Your Honor, 22 CP 214077 is a theft by receiving stolen property, felony, fleeing and attempting to elude, driving while license suspended. 23 CP 216606 is a criminal damage to property in the first degree and interference with government property.
It's a jail case.
Yes, given the date, I was going to say, Your Honor, that seems to have happened in custody.
Yeah.
The last case ending in 609 is a 2021 offense for entering auto. So not a large number of serious offenses, but still felony arrest regardless, Your Honor.
Got it. Okay, thank you. You want to tell me a little bit more about Mr. Bailey?
Yes, Your Honor. So Mr. Bailey is 29. He is engaged to his son Leighton's mother. He also has a 9-year-old stepson. He was working kind of several jobs at the time of his arrest. He was doing what's called recycling for Georgia Furniture, which he was explaining to me what that is. He was also doing roadside car working on with his uncle. And then his brother has a box trucks company where right now their only contract is with Amazon, but theoretically they'll grow and get other contracts for. So
Amazon's not a bad contract to have. They deliver a few packages.
So Mr. Bailey feels like he has good job options when he gets out to be able to get back on his feet. He went through the 11th grade, but then he did get his GED in 2017. And he will be on an ankle monitor as part of the bond, should he post bond in the new cases. So I don't know that we have to be as concerned about future criminal activity, and he's very motivated. As the court heard, his record is not violent. It's not guns. It's not even drugs. It's all property and theft related crimes. Not that that's wonderful, but certainly not what I'm typically seeing with a lot of other cases. So we would just ask the court to consider the somewhat more minor nature of the charges and all of that, and sentence him to the 6 months he's already done, let him work out his other cases.
Ms. Hardy, I didn't mean to skip over you. Can you share with me Mr. Bailey's criminal history, please?
The defendant has 15 arrest cycles in Georgia beginning in 2009. A felony conviction in 2010, theft by receiving stolen property and burglary. 2011, criminal damage to property. 2019, criminal damage to property and burglary. Probation violations in 2013, 2014, 2016, and a parole violation in 2022.
Got it. Thank you.
Mhm.
So, Mr. Bailey, I agree in part with what Ms. Feely says, which is your things you get in trouble for don't seem to be resulting in like physical injuries to people. But for a guy who's only 29, you've been pretty busy, and you got 3 open cases, as in they haven't even been indicted yet. You've got this other indicted case in front of Judge Edwards, and maybe something over in DeKalb County. When are you going to slow down?
It's now or never.
Now or never. It's not quite that bad. You're 29. You got a few more years.
He just whispered something to me and I didn't want to interrupt, but the first 2009, he would have been 16. He believes this is his brother's. I don't know how.
Oh, well, but what I understood Ms. Hardy be saying is his first arrest was 2009. The first conviction was a 2010, but could be. And I'm less concerned about a conviction from 2010. That's almost 15 years ago. It's just more that stuff keeps coming up. The 2019 is not all that long ago. The 3 CP cases, plus the open case in front of Judge Edwards, and maybe a case in DeKalb. I mean, he can gain a year just having to bounce around between all those things, and sort of surprised he's got bond on all that. So you have a step kid because your fiance already has a kid, or is that through a different situation?
My fiance have a kid, one she prior had and one by me.
Okay. Well, the one who's almost 1, you had that with your fiance.
Yes, sir.
And then the 9-year-old or however old.
My stepson.
Okay. So have you seen your son yet?
He was 4 months when I got arrested.
Okay. All right. Got it. Well, Mr. Bailey, I find that you did violate the terms and conditions of your probation by getting mixed up in something in DeKalb County in August of 2022. I'm pretty sure you understand this, but I want to make sure it's on the record. Whatever we do here today doesn't resolve the DeKalb situation. If they're going to bring charges, you're going to have to go deal with them. Looks like you also didn't complete your MRT program.
I'm sorry, I didn't mean to cut you off, but I did all that when I was in prison.
Great. Well, one thing, that's not why I'm real worked up. I'm not real worked up, but that's not why I'm going to revoke some time for you. If you've done your MRT, figure out how to get proof of that and get it to probation so they back off on that. But that's the non-serious thing. This other stuff, you're breaking the law, you're making life difficult for other people, whoever's car you allegedly broke into, it's not good for them. And frankly, if you want to really be there for Leighton, is that the Leighton, and what's your older kid's name?
Peyton.
Peyton and Leighton. Okay. If you want to be there for them, the best way to do it is not to be dressed like that. But you're going to be dressed like that for a while with these different open cases and whatever's going to happen with Judge Edwards, et cetera. So I hope that as you enter your 30s, you think about other ways to make stuff happen. It sounds like there are some legit money-making opportunities out there for you, whether it's working with your brothers who've got that box truck, or
My brother and my mom.
there you go, or some of the other things that Ms. Feely described. Your decision to make as to how it is you want to move things forward. But in light of everything you've got going on with these open cases, what you were revoked for, et cetera, I am going to revoke 10 months. You will get credit for the time you've already served. You'll do a little additional time. And I agree with Mr. Jordan. I think we ought to suspend the balance of your probation. There'll still be some left, but you are going to get sentences coming out of Judge Edwards, coming out of these CP cases, maybe coming out of DeKalb. And I don't see the value in layering all these things. One of them is going to run longest, and that'll be what you'll need to comply with as you go forward. Anything else, Mr. Jordan, from the state?
Nothing further from the state, Your Honor.
Ms. Feely?
No, Your Honor.
Okay, thank you. Oh, let me make sure. Ms. Tucson, did you need anything else or are you good?
I just wanted to confirm the date of credit for time served, because sometimes what we have in the system is different. If you have it, Ms. Feely.
November 18th of 2022.
Okay. And then if Mr. Bailey's balance is going to be suspended, this probation will close out and it will, close anything active now unless he's sentenced to probation. In the other cases, and you said it's DeKalb, so he'll have to report somewhere in DeKalb.
Right. He just won't be reporting on this. This will close this out. He'll serve the rest of the revocation, and then he'll hopefully be able to sort out some of these other charges while he's doing that.
Okay. Good deal.
All right. Thanks so much. That's it. Appreciate it.
Thank you, Your Honor.
Thank you. Nice work. I didn't even notice Mr. Jordan wasn't here. It was like he'd never been here. Oh yeah, wait. So tomorrow, he can go. Sorry. And let me thank everyone else. Ms. Tucson, Ms. Hardy, thank you so much. You all are free to go. Ms. Willingham, stay on for a second.
Thank you, Your Honor.
You're welcome. So we're calling the calendar tomorrow, and I think we didn't have the, hey, what do we want to go out to trial on meeting, because Ms. Wood wasn't available, and Ms. Nelson was on vacation. And so she just mentioned that. We don't need to do it right now, but if it would be helpful, I guess we can, after we call the calendar, we could see what happens without doing that. You guys will say, Judge, I really want to do that meeting next time. But we didn't do it this time. So it's a long calendar. Because of some vacations, we didn't have that nice lead in where, hey, I've got a plea. So tomorrow, maybe we'll work a bunch of cases out. Maybe we won't. It's a 1 week calendar. So we can probably only try one thing that starting next Monday. And Mr. Shapiro may be tied up till Tuesday. I know you're saying Kuntz may work out, but nothing will happen with it if we can't get Shapiro. And that's 4 cases. So, or at least 3. I don't know how we've sorted out his Eric Johnson case. So I offer up, if you guys want to talk about the calendar, we can. If you just want to see what happens tomorrow, and then I'll just shoot out an email saying this is what's left. Or we can, after we call the calendar, you can say, these are the 3. Can we just have it be these 3 of mine and these 2 of mine that we tee up for Monday? Normally, Mr. Peoples, what we do is we would have yesterday or late last week gathered informally, and I just go straight through the calendar. Hey, who's going to be? Is this one? Yeah, this is going to be a plea. Don't worry about this one. This one already pled, Judge. Don't you remember? And so you all have a sense, leaving that of your 16 cases on there. Maybe these 5 or 6 are the ones that you really ought to focus on. We weren't able to pull that together this time.
Understood, Your Honor, and I know
We can run
you were
through it.
making reference to Mrs. Attorney Shapiro's cases. I think for Kuntz, I think I'll be able to handle that.
Okay.
Those 3 as well, but
Well, who needs Shapiro?
but I'm here for court's pleasure, so we could run through it if needed.
Why don't we go through it real quickly? Ms. Willingham, do you want to stay on, or should I just drop the Zoom? Yeah, but she's not there.
I just text her, Your Honor.